You're ready. All right, good morning, everyone. We are on the record once again in cases 2025-000113 and 2025-000114, Kentucky Utilities and Louisville Gas and Electric. And we already had Mr. Conley on the stand. Remind you, you're still under oath. And where were we? Mr. Fisk, were you still? Okay.
Your Honor,
Yes.
could I do one logistical thing just on
Sure.
witness order, just so everybody has fair notice of it? Because of where we are in the schedule, and that Mr. Conroy is still on the stand, we need to move up two of our outside consultant witnesses
All right.
to accommodate their travel arrangements. So what we would like to do is when Mr. Conroy is finished, our next witness will be Mr. Spanos. And then after Mr. Spanos will be Mr. Diascendis. And then we'll go back to the order on the witness list, with the exception of what I said yesterday, Mr. Lyons will be at least, I think, at least sometime tomorrow.
It'll be further down the list.
Yes, Your Honor.
And the other movement you made yesterday,
I'm sorry?
you made one other movement yesterday
Yes.
besides Mr. Lyons?
Mr. Beller will be after Mr. Garrett.
Gotcha. Okay, so we'll do Spanos, Diascendis, Garrett, and then Beller.
Yes, Your Honor.
Hopefully, might be optimistic there, but
Yeah, I know I am.
all right. Please proceed, Mr. Fisk.
Thank you, Your Honors. Good morning, Mr.
Good morning.
Conroy. How are you doing?
Good. How about
Good.
yourself?
Doing all right. So wanted to turn to the generation cost recovery adjustment clause that you provided testimony about.
Okay.
Okay. And if I'll call it the GCR
Yes.
mechanism or tariff. So my understanding is that this proposed mechanism would allow for the monthly recovery of the capital and non-fuel O&M costs for certain generating assets. Is that right?
Yes, I believe that's spelled out in the testimony.
Okay. And on page 7 of your stipulation testimony, which the October 20th filing, you identify on lines 6 to 7 a series of generating units that it would apply to. Is that correct?
Correct.
Okay. And so here in this proceeding, the companies, am I correct, are asking for approval of the creation of that mechanism and approval of including these generating units listed in your testimony for recovery through that mechanism?
I mean, that is part of the stipulation in this case. As part of the agreement to stay out, the two mechanisms are part of the stipulation and what we're asking the commission to approve.
And the specific units listed in your testimony are the units that you are asking for costs to be flowed through the GCR?
Yes, it would include all the generating units except Mill Creek 6 that have been approved by the commission as of today.
Okay. And if future, like if next year, say you propose another generating unit, and that if that were approved by the commission in a CPCN docket, would that generating unit automatically qualify for pass-through of cost to the GCR?
The GCR would include the units that are specified here. If there are future units, that will be addressed at a future time with the commission if needed.
Okay.
So no, it will not automatically be included.
Okay, so that you would have to request and the commission would have to approve for a future unit to be included.
Correct, and what we're asking for is the mechanism, the mechanism itself, not approval of any of the cost recovery.
Okay, and as with MC, the Mill Creek 2 mechanism we talked about yesterday, that it's kind of a similar structure?
Yes, it's separate from the GCR, but it is a mechanism itself.
Okay, and similar to with the Mill Creek 2 mechanism, the GCR, the costs, you would file a monthly report 10 days before the costs are recovered.
Yes, as spelled out in the testimony, it'll function the same as the Mill Creek 2, same as the ECR. We will file the forms and the calculation of what's included in there 10 days before the billing cycle goes into effect. I will say the GCR will not start until the first unit actually goes in service in 2027.
And that's expected when?
The battery, the brown battery, I believe, is in the first part of 2027, April, May timeframe.
And then once, so you file your 10-day notice, the charges start flowing through the GCR, and then your proposal is annual review filings after the costs have been recovered?
Correct.
And that would be the first opportunity for the commission to review the prudency of the costs that were flowed through the GCR?
As I mentioned yesterday on Mill Creek 2, staff has the opportunity to review each monthly filing and ask questions if they see something that they need to ask about.
Okay. But for the commission to do a prudency review, that would happen after?
In an open proceeding, yes.
Okay, and is it the company's position that that review proceeding should have the same standards of review as an ECR review proceeding?
Yes, I mean, it would be the same type of review process to look at the prudency of the cost.
Okay. Okay, so, and my understanding is that this GCR proposal is also the same structure as what's proposed as the proposed Mill Creek 6 adjustment mechanism that was dealt with in the CPCN docket. Is that correct?
The Mill Creek 6 mechanism was part of the stipulation of the CPCN that was denied by the commission. The companies are not addressing anything related to cost recovery for Mill Creek 6 at this time.
But it's that those are the same structure, correct, in terms of 10-day reports?
There are some differences between what was contemplated in Mill Creek 6 versus the GCR.
Okay, but in terms of the reporting and the review?
There is ongoing review for all the generating assets that we agreed to in the stipulation in this case, or in the CPCN case. So there's an ongoing review. Regarding Mill Creek 6, the commission's opened up a separate docket to monitor the construction of that unit, but that has nothing to do with cost recovery.
Okay. I guess I was just talking about that proposed mechanism and just wondering if that proposed mechanism was the same 10-day filing of costs beforehand and then the annual review afterwards.
As included in the stipulation in the last case, it would be contemplated that it would be the same type of filing, same type of forms, same type of process to file with the commission before it goes into effect.
And so for these adjustment mechanisms, would the monthly reporting that is filed be separate filings from the two companies?
Yes, there would be, for the units that are owned by KU, there would be a KU filing, a billing factor, and for the units that are owned by LG&E, there would be a LG&E filing.
Okay. And similar with the annual review filings, they would be separate for the two companies?
Yes, typically, unless the commission opens up a consolidated case.
Okay, so if all three of the mechanisms, the GCR, Mill Creek 2, Mill Creek 6, ended up being approved, the companies would be making 5 or 6 monthly filings in advance of collecting costs through those mechanisms?
Again, Mill Creek 6 is not being requested for approval, so it's not an issue in this proceeding. For the GCR, yes, there would be 2 filings every month. For the GCR, there would be 1 filing for Mill Creek 2, just like there is 2 filings for the ECR, 2 filings for the FAC every month.
Okay, so between GCR and Mill Creek 2, you're talking about 3 additional monthly filings and 3 additional annual review filings.
Correct.
Okay. And then if Mill Creek 6 were eventually
Your
approved,
Honor, I'm going
would
to
be
object on the
more.
grounds of relevance. We're talking about a Mill Creek 6 mechanism that has not been introduced into this proceeding. It's not part of this case. I think we've gone far enough down that line.
Okay.
Okay, and if you could turn to the tariff proposal itself for the GCR, which is exhibit, I believe it is Exhibit 8 to this stipulation testimony.
Exhibit 7 is KU's and Exhibit 8 is LG&E's.
Okay, and they're the same text, just relevant to the different companies.
Yes, the text and the operation of the mechanism is the same for
Okay.
both companies.
And you, on both of those tariffs, you are identified as the person issuing them, is that correct?
I'm the person that issues all tariffs for the company.
Okay. Okay, and so for the GCR, if you look under definitions, 1A, it talks about the total rate base that would pass through the GCR, is that correct?
Correct.
Okay, and it includes the last sentence of that paragraph 1A says incremental future additions to these units will be included in rate base and will be recoverable beginning when costs are incurred and recorded to construction work in progress. Is that right?
Correct.
Okay, and what are incremental future additions to these units?
So this mechanism is for the life of the assets. As components fail or get replaced, those are called capital additions over the life of the assets, so those would flow through this mechanism as well.
Okay, and would there be any commission pre-approval of those needed before they flow through the mechanism?
There would not need to be any pre-approval, but there will be the review process like any other investments in the asset.
Okay. And those costs that you were just talking about, is that kind of ongoing capital projects?
Yes, again, the GCR includes these assets in totality over the entire life of the asset. So all costs associated with maintaining the generation would be included in the GCR.
Okay. If one of these units that is covered under GCR is expanded, is that considered an incremental future addition?
What do you mean expanded?
Like, find a way to increase the capacity of it by 200 megawatts?
I can't really comment on that hypothetical. I'm not sure whether these units would be expanded 200 megawatts.
And you're not sure if they were, if that would count as an incremental future addition?
I'm not sure how that would be treated at this point.
How about if you had needed to add, like, you included in the GCR are a couple gas-fired units, correct?
There are 2 NGC, natural gas combined cycles,
Okay.
yes.
If hypothetically someday you needed to add CCS to those units, would that qualify as an incremental future addition?
That's a hypothetical, and most likely something like that to that extent would probably come before the commission for a different reason, for a CPCN or for something like that. So that'll be addressed at a future date if that scenario were to actually happen.
Okay, so it would not be automatically approved as an incremental future addition for cost recovery through GCR?
It just depends on what the investment is and whether a CPCN is needed, and how it would be treated.
So if a CPCN is needed for an addition to the unit, then it would be addressed through the CPCN as opposed to the automatic recovery through GCR?
Yes, if we need a CPCN for any investment, we would file an application with the commission.
But if it's an addition that you don't need a CPCN for, then it would just automatically flow through.
Your Honor, I'm going to
GCR.
object to the form of the question. Mr. Fisk keeps talking about the GCR mechanism being automatic. There's nothing automatic about it. Mr. Conroy has testified repeatedly that the cost to be recovered in GCR will be subject to commission review. Therefore, there's nothing automatic about it. So if he could rephrase his question to exclude the term automatic, these questions are fair. But I object to the form of the question.
He has answered that he doesn't believe it's automatic,
Okay,
but you ask your question.
okay,
I don't have a problem with the way you're asking your questions.
okay, thank you, Your Honor. If the addition to the unit does not need a CPCN, would it is it the company's position that it would be qualified for recovery through the generation cost recovery, subject, of course, to the 10-day filing before actual charges are passed to the customer?
Again, the GCR mechanism is to recover over the entire life of the generating unit, all non-fuel costs associated with the unit. So everything associated with that unit would be addressed in the GCR, subject to commission review and prudency reviews.
And if you don't need a CPCN for whatever those projects are, the only opportunity for commission review in advance of the recovery of those costs is the 10-day filing and monthly reporting to the staff.
Again, just like the ECR, actual costs will flow through the mechanism for every generating unit that's included in this. The commission has plenty of opportunity to review those costs.
So the answer to my question is correct, right?
Rephrase your question.
If the incremental future addition to the unit doesn't need a CPCN, the only opportunity for review before the costs are passed through the GCR mechanism is the 10-day monthly reporting, correct?
Again, the commission has the opportunity to review those costs. It is a mechanism to recover actual costs, subject commission review, prudency reviews on an annual basis. They will be included in the mechanism and billed to customers as it functions, subject to commission review after the fact.
Okay. In the absence of the GCR, let's say if it were not approved, the capital cost at issue that you're proposing to pass through the GCR, how would those be recovered?
Absent the GCR, those costs, like all other costs the companies incur, would be included in a base rate case.
And so those costs would not be able to be recovered until the commission had an opportunity to review the base rate case and approve or deny it.
They would be reviewed along with all other costs in a base rate case proceeding.
In advance of when they're recovered.
Correct.
And I think this is just a clarification question, but then the companies are proposing a 9.9% ROE for the GCR, correct?
Correct.
And is that 9.9% ROE apply for the life of the asset, or is that just until the ROE might be changed in a future rate case?
The ROE is always subject to change by the commission in future cases.
Okay, and if it was changed and the base rate ROE changed, would the GCR ROE change also, or?
Yes, if it's addressed in the rate case, it would change with whatever the commission order says.
Okay. Okay, and we touched on this briefly yesterday with Mill Creek 2, but the GCR mechanism would also use the Group 1 versus Group 2 allocation process, is that correct?
Correct.
Okay. And that, at a high level, Group 1 is basically residential and some local government entity customers?
The tariff under availability lists out what rate schedules are in Group 1 and what rate schedules are in Group 2.
And
They're listed in the tariff.
I understand, but I'm just asking, generally, Group 1 is residential and some local
Again,
government?
it's listed out here what they are. It's RS, RTOD, RTOD demand and energy, volunteer fire, AES for KU, and the lighting rates.
Okay, RS is residential.
RS is residential.
And Group 2 is generally industrial and larger commercial customers?
Group 2 is all of the rate schedules listed in the tariff.
And those include industrial and large
They would
commercial customers?
include commercial customers, industrial customers, anybody on the rate schedules listed, listed in the tariff.
And am I correct that this Group 1, Group 2 methodology tends to be favorable to industrial customers?
Not necessarily. The way the Group 1, Group 2 functions is the revenue requirement is allocated between the two groups based on total revenues. And then within the groups, the billing factor for Group 2 is determined based upon total non-fuel revenues. It will tend to provide benefits to high load factor customers based upon the level of fuel that they burn, they use.
Do you have your, if we could refer to your rebuttal testimony from the CPCN docket?
I don't have that with me, but
Is that,
As I said, it's going to take Mr. Lovecamp some time to get there.
okay.
He does not have that on the machine. What he has on his machine is just on the hard drive on that machine, which is the record of this case.
It's on our website, if someone can give him a specific reference to location.
What I'll do, Your Honor, if it's okay, is I'll pull it up on my machine and then hand my machine to Mr. Conroy so we can.
yeah.
It was July 18th, 2025 on the docket.
July 18, Mr. Fisk?
July 18th.
Okay,
Yes.
just a minute, please. want the mouse, Mr. Conroy, or you touchpad?
Okay, I'll take the mouse. Thank you.
Okay, Mr. Conroy, I believe you now have in front of you a copy of your rebuttal testimony from the CPCN docket, is that correct?
Yes.
Okay, and if you could turn to page, what's page 11, it's PDF page 13.
Okay.
Okay, and beginning at line 8, there's a discussion there about, in that proceeding, AG KIUC's proposed generation cost recovery rider. See that?
I see that.
Okay, which you referred to as unreasonable and unnecessary. Is that right?
In that proceeding, yes.
Okay. And if you look to, scroll down to the next page, line 1, says that notably AG KIUC proposes to use the same Group 1, Group 2 methodology. Do you see that?
Which line?
Starting on line 1.
On the next page?
Yes, on page 12.
And again, this proposal was related to Mill Creek 6.
Yes, understood.
Okay.
But you see the reference there to the Group 1, Group 2 methodology?
Yes.
And that's the methodology we've been discussing here?
Yes.
Okay, and you state on line 2, which tends to be favorable to industrial customers?
Yes.
Okay,
And
so are you-
typically, they're higher load factor customers.
Okay, so you do agree that the Group 1, Group 2 methodology tends to be favorable to industrial customers?
Yes, and it's been in place since about 2011 in the ECR.
Okay. 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 That's all on that document if you want your laptop back. Okay, and so under the GCR, EHLF customers, that's the extremely high load factor customers, which are mostly data centers, correct?
Correct.
Okay, and they, the proposal is to include them within Group 2?
They would be within Group 2, yes.
Okay, and so, and those are even higher load factor customers than the industrials typically are?
Typically, the data center customers would be in the 90-some% load factor.
Which is higher than the current industrial customers?
Typically, yes.
Okay, and so the inclusion of EHLF in Group 2 would tend to be favorable to the EHLF customers?
It would tend to be favorable, but again, as I said, the Group 1, Group 2 methodology has been around since 2011 with the ECR allocations. It is a reasonable allocation of capital cost.
And so the allocation of the Group 1, Group 2 allocation for GCR would allocate approximately 43% of the cost to Group 1 and 56% to Group 2, is that right?
Based upon the bill impact in the supplemental testimony Exhibit 1, it's about 40% based on total revenues of the revenue requirement be allocated Group 1, and roughly 60% for KU would be allocated Group 2. For LG&E, it's about 44% Group 1 and 56% Group 2.
Okay. And do you, have the companies evaluated whether those percentages would be, those allocation percentages would be different if these costs were recovered through traditional base rate recovery?
Back when this methodology was established in 2011 in the ECR, back then we did some analysis at the request of the commission that showed that the method of allocation using Group 1, Group 2 was fairly consistent with the traditional allocation using 12 CP, 6 CP, different methodologies that would be included in base rates. So it's been demonstrated in the past that it is a reasonable approximation of how base rates would be recovered. We haven't done that analysis recently.
Okay. And so you're saying in 2011 or 2012, you said that was done?
It was established in the 2011 ECR proceeding. Sometime thereafter, through review processes, we did an analysis to demonstrate that it was a reasonable approximation of what was in base. I don't remember the exact year. It was sometime within about 4 or 5 years after the establishment of the Group 1, Group 2 methodology.
And that compared Group 1, Group 2 methodology to recovery through 6 CP or 12 CP?
I don't recall exactly which methodology, but it was looking at the methodology of allocating cost in the base rate case.
Okay. Is that something that you could produce in a post-hearing data request?
I assume it's in the record in previous proceedings, so yes.
Okay. But you've not done any updated analysis since then, comparing?
We have not.
Okay. And so there's no analysis of how EHLF load might impact that cost
There's not.
allocation? Okay. Your Honor, I wanted to turn to the work paper from yesterday. I don't know if the commissioners have
We did.
received that yet. Okay, great. Okay, so, Mr. Conroy, in your supplemental testimony, it was filed on Friday, there is a discussion starting at the bottom of page 6, page 6, line 20, if you could turn there.
Yes.
Talking about saying that there's a benefit of adjustment clause GCR because capital assets included for recovery will have a declining capital balance due to depreciation and therefore declining cost of capital. Is that right?
Correct.
Okay. And is that am I understanding correctly that basically the benefit is because it's a monthly charge that's reset every month as the undepreciated value on the capital asset is paid down, the amount of
Yeah,
depreciation
the
is
significant benefit of the mechanism is that it is a monthly calculation,
Okay.
and it doesn't start until the unit goes in service.
Right.
So after the unit goes in service, it starts getting depreciated. So there's a declining rate base in that calculation, which significantly benefits customers relative to having the asset included in base rates, which in base rates, it's only reset in the test year of the rate case. So the customers are getting a significant benefit for that declining balance real time.
Okay. So as they pay off the undepreciated value, that leads to the declining base.
Well, the function of the mechanism is that depreciation expense is included. And as depreciation expense over the life of the asset, the depreciation increases, which lowers the rate base, which lowers the return on rate base for
Okay.
determining the billing factor.
And through GCR, that would reset every month. Through a rate case, it would only reset every maybe 3 years. Or
Yeah, and the example that's in the rebuttal testimony that was part of the work paper, it was comparing the perfect rate treatment through the GCR to a scenario in which there were rate cases every 3 years for the life of the assets. So you see the declining balance and the benefit. You actually see that in the bill impact calculations in Exhibit 1 as well.
And do you have the work paper that your counsel provided us yesterday?
I do have it up, yes.
Okay. And this is the work paper that was used to create the table that is on page 7 of the supplemental testimony. Is that correct?
That is correct.
Okay. And what was your involvement in creating this work paper?
I did not create it, and I was not involved in it. I would defer to Mr. Garrett and Mr. Beller to talk through this, but in general, I understand what the numbers represent, and they represent exactly what I just explained, in that you have a scenario in which the assets are recovered through the GCR on a monthly basis, relative to a scenario in which there is a base rate case every 3 years, and those assets are recovered in the rate case. You can see in this the benefit of the declining balance by looking at the difference between perfect rate treatment line and the periodic rate case lines.
And the,
For example, in 2027, you see that it's 198, I believe those are millions. Yes, million for perfect rate treatment, and you see it's 198 for rate case. The next year, the next 2 years, the rate case, you're recovering 198. Whereas for the mechanism, it's declining to 192, it declines to 183. So that is the significant value of the declining balance through the mechanism.
and so the perfect rate treatment, that is the GCR, that's what you call it, GCR in this spreadsheet?
That's the GCR, yes. That's just the nomenclature that was put into the spreadsheet.
Okay, so,
And that assumes a rate case every 3 years.
The periodic rate case assumes one every 3 years for the life of the assets, relative to the GCR mechanism in the upper half.
and those periodic rate cases are in the years that are marked with a Y in line 25?
That's correct.
Okay. And that is, and those years marked with a Y would be the years that the undepreciated value that factors into the rates is reset?
The year in which the rate case occurs, you have a test year, and whatever the assets are at that point in time is what's included in rates.
Okay. So for the perfect rate treatment GCR analysis, let's look at Mill Creek 5, line 15. So, year 1, it's 112, and then it goes down to 111 the next year, 108 the next year, and then 105 in 2030.
Correct.
Okay, and that's the amount of depreciation that the customers are paying each year?
That is the revenue requirement for that scenario.
Okay. And then for the Mill Creek 5 under the periodic rate case, line 26, it's 112 for the first 3 years, and then it drops to 105, correct?
Yes, because in a rate case, it's set based upon that test year and held constant.
So my question is why, given that in the periodic rate case scenario, customers have been paying more for the first 3 years than in the GCR scenario, why does the value in the periodic rate case in year 4, when the rate case happens, reset to the exact same value as it does in the GCR scenario? Why wouldn't that value in the rate case, in the periodic rate case, be lower?
I'm sure Mr. Garrett can explain it in more detail, but essentially, the test year in the rate case would be the same numbers as what's recovered through the GCR. So that's why they would be identical. In the years in which a rate case occur, you have the same cost, that your cost profile, same rate base, the same depreciation as was recovered in that year for the GCR. So it's just a matter of which mechanism you recover that test year cost.
Even though the customers have been paying more of the depreciation for the previous 3 years?
Yes, but when you get to the rate case, that depreciation, accumulated depreciation expense would go against the rate base in the test year. And again, Mr. Garrett could explain more detail on how that functions,
Okay.
that
I will.
accounting aspect.
Okay, I'll reserve the questions for him then on that. Okay, your stipulation testimony, page 22. And this is changing topic a little bit. You have a reference, line 13, about, well, it's in a discussion about rate EHLF. And it says,
I'm sorry, which page are you on?
I'm on page 22.
Oh, 22.
So actually, starting at the end of line 11, it states, rate EHLF addresses all of these items to provide reasonable protections for the companies and their customers, while also providing average embedded cost rate service to all customers. You see that?
Which lines are you on?
It's starting at the very end of line 11.
Okay.
And what is average embedded cost rate service? That means that the rates are based on the cost of all of the resources in the current resources in the company's portfolio.
All of our rate schedules are based upon embedded cost of providing service, which includes all the generating assets, transmission, distribution, common plant, everything that's in a rate case that is included in the cost of service study that allocates cost to each of the rate schedules. So it's embedded cost-based rates for all the rate schedules.
And are you aware of a concept of marginal cost rates?
I am aware of that, yes, but that's not what Kentucky's structure is. It's embedded cost rates,
Okay, and what would marginal cost rate be?
where it would take into consideration incremental cost.
Okay, and the incremental cost that, say, a new customer might be
Yes,
adding to the system.
yes.
Okay, so for example, the Brown 12 gas plant approved in the CPCN that you're seeking to pass through the GCR, correct?
Correct.
That is based on load forecasts that assume a significant amount of data center and other economic development load, correct?
I mean, all that was discussed in the CPCN. It's based upon the company's load forecast for all economic development and serving all customers, all existing customers.
So a marginal cost approach would look at if certain customers, new customers to the system were creating the need for a generating unit, you could factor that into their rates, correct?
I've not done marginal cost of service studies, so I can't tell you exactly how it would work. But conceptually, if that's the way certain states operate, then it would tie a generating unit to a load. That is not the way Kentucky operates, in that all generating assets that we build and construct are available to serve all customers,
Okay.
new and existing.
So the companies have not evaluated using marginal cost rates in the context of EHLF customers that might be coming onto the system, correct?
Again, as we explained in the CPCN, all the generating assets are planned to serve all existing and new customers. We have an obligation to serve all customers.
So
We do not build specific generating units to serve a specific customer. They are there to serve the entire system.
So the answer to my question is that,
Your
correct,
Honor.
you have not evaluated
Your Honor,
marginal costs.
I'm going to object to this business where Mr. Fisk asks a question. Robert Mr. Conroy provides an answer, and then Mr. Fisk recharacterizes and says, the answer to my question is thus and such. The answer is the answer that Mr. Conroy provided.
Oh,
Your response?
I understand the answer you provided. I'm also trying to get him to confirm that they did not evaluate. My question was simply, have they evaluated marginal cost as a way to serve EHLF customers?
And
He
Mr.
gave an
Conroy,
answer, and I'm trying to confirm they have not evaluated that.
Mr. Conroy answered that question. In that case, it's asked and answered.
I tend to agree. I think it's asked.
Okay, thank you. Okay, I have no further questions.
Okay. So next would be Walmart. Ms. Grumman, do you have questions? Okay. And then KBCA?
KBCA does not have any questions.
Okay. On behalf of Kroger, Mr. Boehm?
No questions, Your Honor, thank you.
Okay, and then back to Mr. Osterloh for the cities, Louisville and Lexington?
Yes, Madam Chair, I do have some questions. Good morning, Mr. Conroy.
Good morning.
And just be advised that these questions are coming from my role as counsel to Louisville Metro Government. The Mill Creek 2 cost recovery mechanism that you discussed in your supplemental testimony that was filed on Friday was a component of the stipulation and agreement entered into by some of the parties in the 2025-045 CPCN case, correct?
Correct.
And that stipulation in the CPCN case included a provision that the stipulating parties agreed that the stipulation does not impair, limit, or otherwise interfere with the jurisdiction of the Louisville Metro Air Pollution Control District, correct?
I believe so, correct.
Okay, and I'll refer to the Air Pollution Control District as APCD. Are you aware that the APCD implements air pollution regulations and issues permits related to air quality in Jefferson County?
I am generally aware of that, yes.
Are you aware that APCD is an independent body that is separate from Louisville Metro government?
I am generally aware of that, but that's not my area of the company.
With respect to Mill Creek 5, are you aware that the APCD issued a construction permit that contains language reflecting the retirement of Mill Creek 2?
Again, I am not responsible for the environmental aspects, but generally I'm aware that there are provisions in the construction permit. Exactly what's in there, I can't say.
Okay. And oftentimes the companies have, I believe, Philip Ember testify as to these matters. Is that correct?
That's correct.
And he's not a witness in this rate case, correct?
He is not a witness in the rate case.
Okay. So assuming the APCD issued a construction certificate, or I'm sorry, construction permit for Mill Creek 5, with language reflecting that there would be the retirement of Mill Creek 2 prior to Mill Creek 5 becoming operational, does LG&E agree that any service life extension to Mill Creek 2 beyond when Mill Creek 5 is operational would require LG&E to seek a new permit from the APCD?
Again, I'm not responsible for environmental permitting. Mr. Beller might be able to address that specific question.
So you don't know whether APCD would require initial permit?
Again, I'm not over the environmental, so I can't really respond to that. Mr. Beller might be able to respond more specifically.
Thank you. That's all the questions I have.
Okay. So, staff?
Morning, Mr. Conroy.
Morning.
A lot of our questions are related to the stipulation, but if it's better for Mr. Garrett, just let us know, or if it's anything specific that's better for another witness, please just let us know.
I sure will.
Okay. Could you first kind of talk about how the decrease in the electric revenue requirement for both LG&E and KU from what was originally proposed impacts KU and LG&E's planned capital projects?
The stipulation in the revenue requirement does not change our plans for our investments to adequately serve customers. We still plan to invest in the transmission, distribution, IT systems in the same manner in which we put forth in the case.
And is that the same question for LG&E Gas? Same answer?
Yes, it would.
Okay. Is there any type of budget impact related to this decrease?
What do you mean by budget impact?
So like, is the lessening of the revenue requirement mean that anything from the originally planned, like, capital budget, would anything need to be moved around related to this decrease?
I can't specify that. Mr. Garrett might be able to talk more to the budgeting process.
Okay. And I have some questions relating to the sharing mechanism. So the stipulation testimony specify that there are certain criteria that would void the stay-out commitment and authorize LG&E to come in for a rate case before the end of the stay-out commitment. If one of those criteria applied, and LG&E KU were to come in for a base rate case before the end of the stay-out commitment, would the adjustment clause SM stay in effect through the specified time period, or would the base rate case void the adjustment clause SM?
Is there a specific area in the stipulation that you're referring to on that?
Yeah, so if you look at the stay-out conditions, there's kind of, like, for example, the emergency rate relief, the cost I think it would mostly be the emergency rate relief. Or if there's a statutory regulatory change that might require LG&E KU to come in for a rate case sooner.
Again, the companies would not anticipate any of those exclusions coming into play. Again, it would be a very extreme situation to where those would be triggered. That is standard provisions that we've included in past stipulations related to stay-out provisions to ensure that if something were to happen, the companies would still be able to come in for a rate case, make changes, and be able to stay financially viable.
So if one of those extreme conditions did happen, would the SM clause be voided at that point?
I'm not sure one way or the other on that.
Okay, do you know if somebody would be able to answer that question?
That may very well be a legal question.
Okay. And can you explain how the 9.4% floor on the deadband compares to LG&E and KU's past earned ROEs?
I do not have the past earned ROEs in front of me.
Okay, as a post-hearing data request, could you provide the earned monthly ROEs for the past 5 years?
We could respond to a question asking for information on the past earned ROEs, yes.
And can you explain how the earned ROEs as specified in the stipulation will be calculated? For example, will it be a monthly average calculation and correction over the adjustment clause SM stay-out period, or the earned ROE at the end of the adjustment clause SM stay-out period?
I would defer to Mr. Garrett on that specific type of calculation.
Okay, so is the kind of questions maybe specifically related to the ROE maybe better for Mr. Garrett?
You can ask the question, and
Okay.
I'll do my best, and if I need to, I'll defer to Mr.
Okay,
Garrett.
that sounds good. So if LG&E KU were to earn a monthly ROE above the ROE deadband of 10.15%, would LG&E KU distribute the revenue surplus in excess of the 10.15% of the deadband, or in excess of the authorized ROE of 9.90?
To the extent that the calculation of the earned return is above 10.15, it would distribute the level above 10.15 back to customers.
Not above 9.9.
No, just like if the companies were under the deadband of 9.4, it would collect only the amount up to 9.4.
And as a post-hearing data request, could we just get an example of a situation in which the ROE is above the 10.15%? Like kind of a calculation of how that would show onto a customer bill?
Yes.
Okay, thank you. The stipulation states on page 15, section 7.4C, that KU and LG&E will make appropriate capital adjustments described in the direct testimony of Andrea Fackler, inclusive of new adjustment clause, generation cost recovery, and sharing mechanism as applicable. So as some of those adjustments were specific to the forecasted test year, do you plan to make those type of adjustment to actual expenses when determining the earned ROE for the sharing mechanism?
What we would make is the typical adjustments to remove other mechanisms. I do not believe those would be the same type of adjustments we'd make in the SM 13-month period. It is really to represent the kind of standard adjustments to remove mechanisms, to adjust for the deferral.
13 months was chosen rather than 12 months?
As part of the stipulation, in tying with the stay-out provision of rates couldn't change until August of 2028, and the fact that the generating units go into service in June of 2027, the stay-out period to include in the sharing mechanism was the 13-month period between those dates.
Okay, and how do you plan to normalize revenue over the 13 months?
I believe, as we said in the testimony, given that there are 2 Julys in that, we would adjust the second July to be kind of the average over the 12-month period applied to the customer balance in July. And then that would be factored into the 13-month average.
And is there any additional complications related to billing determinants due to a 13-month period?
I don't believe so.
And are you intending that any regulatory liability or asset balance created as a result of the earned ROE falling outside the deadband accrued interest at the WAC?
I'm sorry, can you state that again?
Sure. Are you intending that any regulatory liability or asset balance created as a result of the earned ROE falling outside the deadband accrued interest at the WAC?
I don't know if that is addressed, but that's something Mr. Garrett could probably respond to.
What's the potential bill impact to customers of implementing the true-up in a single month?
That would all depend upon what the dollar value is at the end. Again, as this will be billed or returned to customers over a 13-month period, there's a lot that could occur during that 13-month period on weather, load, and revenues. It won't be perfect. In the end, we will look at whatever the balance is and calculate a billing factor based upon that following month's billed revenues to hopefully get it as close as possible. We've done similar types of true-ups on past mechanisms. I think most recently in the annual surcharge that we had in the last rate case.
Then you would anticipate that this true-up would kind of run in the same fashion as the one you just mentioned?
Yes. Yeah.
I'm next turning to the generation recovery rider. Can you explain the benefit of maintaining the adjustment clause GCR as a line item on customer bills from the in-service date through the retirement dates as opposed to rolling the respective project costs into base rates?
Yes. As I mentioned earlier, the declining balance over the entire life of the generating units is significant to customers. So that is the significant benefit of it versus rolling it into base rates.
And what's the benefit to the companies?
having a constant mechanism for the generating assets itself. And I think as we've seen in past ECRs, there are some complications with moving things from mechanisms to base rates. It provides a standalone mechanism for the life of the assets. It gives the commission the opportunity to review those over in isolation of everything else in a base rate case proceeding.
And you talked about the review period for the GCR. So if, for example, like during the review period, so let's say like before it goes to the customer bills, like there is like some type of issue that the commission finds, that would just be removed and then it would not run through the GCR, correct?
Typically, what's happened, if there are calculation errors in the monthly filing, I've had staff call me directly in the past and say, hey, take a look at this. We would redo the filing before the billing factor goes into effect.
So you would expect to kind of be an informal process, like on the front end?
That's one way to approach it. That's typically how it's happened in the past on fuel adjustment clause. It's been a while since I've been engaged in the monthly filings, but years ago, I've had conversation with staff between the 10-day period.
And so in like the longer, like in the yearly review processes for the GCR, if like on the back end, if there was an issue where the commission disallowed an expense, then what would be the process from there, from the company's perspective?
Similar to the review processes in the ECR, if there's an issue during the review period, we would recalculate what should have been billed, and that would go into a true-up for the mechanism.
And, sorry, I'm just looking at my questions. Some of them have been answered. And can you explain why the stipulation has a 9.9 ROE for assets being recovered through this rider?
It's part of the stipulation and compromise amongst all the parties that the ROE would be the same for the mechanisms as in base rates.
And would this mechanism generally present less risk to shareholders than base rate recovery?
I would not say it'd be less risk. There's still significant risk associated with prudency reviews going forward. I believe Mr. Cindy's could comment on risk associated with mechanisms versus base rates.
Okay.
Who did you say?
Diascendis. Sorry.
Okay. The stipulation specifies on page 13, it's section 6.1A, that property taxes for the first year shall be based on the construction work in progress, balanced at the first of the year, not the in-service cost. Could you clarify what is meant by first year? Is it the first year the mechanism is in place, or is it the first year that each individual asset would be added to the mechanism?
I will defer that to Mr. Garrett to comment on.
And does the company plan to recover cash working capital and the generation cost in this GCR mechanism?
If you look at the forms, yes, we've got a cash working capital component listed in there.
And is it going to be based on the 1/8 method?
Yes, that's what's included in the forms, very similar to the ECR mechanism.
Is there any reason that it's not being proposed, like the lead lag study method is not being proposed to be used?
This was modeled after the ECR mechanism, and for simplicity, the 1/8 is what's been used in the ECR. So we carried that forward with these two mechanisms. Again, these two mechanisms are structured pretty close to the ECR, the function of the ECR for simplicity.
Okay. And can you kind of explain the measures that the companies will take to ensure all the costs included in this rider are not also recovered from customers in base rates?
Can I say that again?
Oh, sure. So how will the companies ensure that all the costs included in the rider are not also recovered from customers in base rates?
Mr. Garrett can probably comment more on the accounting, but again, these are individual assets, and the costs associated with those assets will be tracked separately and included in the mechanism. So given that it is the entire assets, it should be fairly straightforward to track the costs associated with those units.
Okay. I'm just going to ask you a few more questions about the Group 1 and Group 2 methodology, and I know you said that was kind of modeled on the ECR as well. Do you know why the fuel expenses are included in the Group 1 rate but not in the Group 2 rate?
When that mechanism was established, in looking at the way the ECR function is a percentage of revenue. So using total revenues to allocate between Group 1 and Group 2, and then using total revenues for Group 1 holds Group 1 pretty much constant with what it would have got otherwise. So it keeps the residential customers neutral to the mechanism. With Group 2 being non-fuel, Group 2 gets allocated the percentage of revenues based on total revenues, but when the billing factor is determined, it's determined based upon non-fuel revenues, and then that billing factor is applied to non-fuel revenues of each of the Group 2 customer classes.
And was there any discussion about which group the HLF tariff customers should be in?
Not specifically, given that Group 1 is been just the residential and lighting. All other rate schedules are included in Group 2.
And can you explain kind of, I guess let's start with the ECR mechanism, why the grouping methodology was chosen instead of the normal rate allocation?
This goes back to 2011 ECR plan case, part of the settlement discussions with the parties in that case. It was a methodology that was reasonable and replicated similar to cost of service allocations, but on a monthly basis, it's more straightforward than to do kind of a cost of service allocation on a monthly basis.
And as a post-hearing data request, I was wondering if you could provide an updated analysis. You talked about the analysis with the joint interveners about the methodology for Group 1 and Group 2 compared to the cost allocation from a base rate case.
We can do what we can attempt to do that.
Okay.
I'm not sure how long that will take.
And are you familiar with the RAR approved as part of the stipulation in the previous rate case?
Yes.
Okay. So there was a part of that kind of talked about the 12-month average base revenue ending, and I believe that for this it says the 12-month average revenue. I was wondering if there's really a difference between average base revenue and the 12-month average revenue. Is there something specific in that you're referring to so I could look at? Sure. So we're looking at the RAR tariff language and I think the GCR tariff language.
Okay. What we did for the GCR and the Mill Creek 2 is we based it all on base rate revenues. What we realized when we've got the ECR, you've got the RAR, it becomes a compounding effect of which revenues you include. Therefore, we went back for these, instead of trying to compound one mechanism onto the other and include revenues from each of the other ones, we went back to just straight base rate revenues. in the calculation of the mechanisms. That's the change you see on the GCR and the Mill Creek 2 mechanisms relative to what we had in the ECR and the RAR. At
So-
some point in the future, we will likely make some changes to the ECR and the RAR to be based upon just base rate revenues so that we don't have the compounding effect on mechanism on top of mechanism.
So,
At some point, or just look at what point you think?
We'll look at when it's more appropriate at some point in time, and maybe a future rate case.
but the intention is for the RR eventually to encompass the average base rate revenue, essentially.
The way it's written now, it's not that way.
Yeah.
We may come to the commission at a future case and change that.
Now, we're still on the GCR topic, but I'm gonna be looking specifically at the Excel spreadsheet provided.
For the bill impact? that
Yes,
was in
so I'm on
Friday's-
the estimated bill impact tab right now.
Okay.
And just confirm that the annual jurisdictional EM is just a summation of the jurisdictional GCR revenue requirement for each year.
You're referring to,
So like for 2020, so if we're looking at like 2027 and we're in C9, and then say we're going to the GCR KU tab, it would
Okay.
be kind of the summation of the F22 through, say, 2027.
yes, the bill impact on page 1 and 2 is expressed in an annual, using annual numbers expressed on a monthly residential bill.
Okay.
So it is a summation of all the monthly numbers for that calendar year. Again, it's just to present a simplified annual average monthly bill impact. The monthly bill impact will be different each month based on that month's calculation.
Okay. And for the estimated group one, for example, the estimated group one billing factor, so in 2027, that's 3.1%. Essentially, that would be the average increase to a customer bill for that year.
That would be the average monthly increase.
Okay. But that's averaged out over the full year, so each
Yes.
year, like each month would be different.
Each month could be different, but on average for the entire year, it's 3.1%.
So 2030 is when Brown 12 is expected to go into operation, correct?
That is correct.
So once Brown 12 goes into effect, that increases the likely monthly customer bill impact, correct?
On LG&E. And
On
again,
LG&E, yes.
for this, as the footnote says, we didn't attempt to adjust revenues over the time period. We held them constant for a simple calculation, but in reality, there will be increased revenue with increased load that would change these factors.
Okay, do you have any idea of how you expect it to change the factors? Like, would the increase in revenue likely result in a reduction from what is proposed here, or would it likely result in an increase?
To the extent that we add more load with economic development or data centers, that would tend to increase the revenues, which would decrease the calculations, because the revenue requirement would be essentially held constant to what's in here, and then you spread that over more revenues.
As a post-hearing data request, could we request the monthly estimated GCR billing factor for 2030, and then also the estimated bill impact for customers in 2031?
Yes.
And if you scroll down a little bit, I'm kind of on line 42 of the estimated bill impact.
Okay.
And then I think it's column N. Could you just explain what that reasonable check is?
I cannot at this point. Ms. Fackler might be able to explain that detail.
Okay. And could you explain whether the regulatory expense associated with each of these riders will be run through the rider?
What do you mean by regulatory expense?
So the cost of the filings for the case. So like the yearly filings, the monthly filings, any costs associated with preparing the documentation, like any of those types of expenses
I
incurred by
would
the
not
company.
anticipate that any of the types, I mean, those are really all base rate. Labor expenses, staffing, we don't intend to hire any new people for these mechanisms. We'll handle it just like we do all the other mechanisms.
For the GCR, if the O&M costs end up being greater than forecasted, would the greater than forecasted amount still be run through this rider?
I'm not sure I understand the question.
So if like there's a current amount of O&M that's forecasted, if the amount is greater than originally forecasted, that would still be run through the rider, correct?
For the GCR,
Yes.
the GCR will be actual cost. Whatever the actual cost are that we incur is what would be collected in the ECR, not these forecasted numbers.
And now I'm turning to the Mill Creek 2 rider, and I'm going to be looking at the spreadsheet that was provided. And I'm currently at the estimated bill impact tab.
You're referring to Exhibit 5?
Yes, yes.
Okay.
And just let me know when you're there.
We've got it up.
Okay. So it looks like from 2026 through 2030, it looks like the impact related to Mill Creek 2 decreases over time. Is that fair to say? If I'm looking specifically at line 17.
Yes.
Okay. And if I look at kind of the other tab, it's Mill Creek 2, LG, and E. And I'm kind of looking at the jurisdictional MC2 revenue requirement, and I'm kind of going to the end, towards the end of 2030. It looks like the monthly bill impact increases. Is that correct?
You're talking about line 16?
Yeah, line 16, it looks like if we're going into September, I guess skipping October, but then November and December, especially December, it appears that the jurisdictional MC2 revenue requirement is increasing.
It would appear that, it is going up in the latter part of the year. That's just a function of the assumptions used in the stay open costs associated with Mill Creek 2.
Okay. I know currently 2031 was kind of like a potentially anticipated date for winding down Mill Creek 2, but subject to analysis, is that correct?
Correct.
Okay, is that kind of what's being reflected here?
As specifically related to what the stay open costs are for Mill Creek 2, Mr. Beller could probably talk more specifically about those type of costs.
Okay.
Again, we're only going to keep the unit open and spend the money to keep it operating if it's economically viable and makes sense.
As opposed to reading data requests, could we just also request the estimated bill impact for 2031?
It would include some assumptions on if the unit would operate beyond that time period.
Okay, and then I guess could we just request what those assumptions would be as well?
Yeah, you can request it and we'll put together the best estimate we can.
And then still on this MC2 LGE TET, so in October, it looks like starting in 2027, there is a negative O&M value. It appears to be about $224,655 in October 2027. Then if you're looking at October 2030, the O&M amount in red is a negative $1,796,432. Could you explain what is happening here?
I will explain it at a high level. Mr. Garrett could probably comment a little bit more, but these are incremental costs to what's embedded in base rates, and I believe what's embedded in base rates for the month of October has a significant O&M cost. So that's why it's negative.
Do you think it would make sense when kind of looking at like the yearly impact to customer bills, removing the October as an outlier?
Again, these are estimates based upon our best assumptions at this point. The mechanism will only include actual cost. So whatever the actual costs are, is what would flow through the mechanism.
And let me know if this is a better question for Mr. Beller, but generally, what does stay open costs entail? For example, would all the maintenance needed for Mill Creek 2 during the stay open period be considered a stay open cost?
I will let Mr. Beller
Okay.
comment on the operation of the unit.
So I'm kind of shifting gears a little bit here. So in the application, the companies kind of floated the possibility of merging and kind of studying the potential of a merger. If the merger were to move forward, how would the stay out be impacted?
I do not believe the stay out would be effective. With respect to the merger study, that was a requirement to put forth in this case, the potential merger. We continue to evaluate that, but we believe it makes sense at this point. Mr. Garrett can comment more on the merger study. Again, we're not asking the commission for approval of anything on the merger of the companies. We would come forth in a future proceeding if we move forward with merging the two companies.
So I know in the application, you originally asked for the commission to kind of say that the merger study was a reasonable plan. Is that still something the company is asking for at this time?
Yes, I mean, we're just, again, it was a requirement that we filed a merger study, and we did so. And we believe it is a reasonable plan to move forward. We would just ask the commission to recognize that report is a reasonable.
But if both parties are bound by the stay-out provision, a combined company, assuming that happened, in the next
Yes,
few
we would
years,
still be bound by the stay out.
And by reasonable plan, are you talking about the contents within the plan, or are you talking about what was provided, not necessarily the content?
I would say what was provided and not necessarily the content, but in the past, we had some pretty critical comments from the commission in orders on this study. We believe we put forth a very reasonable analysis at this point. And we'll look forward to future studies on this.
And the merger study isn't really talked about in the stipulation, correct?
It is not. Again, there's nothing we're asking for approval on for merging the two companies. Again, that would be a future case before this commission.
Now I'm switching to the topic of rate design. And I'm looking at the joint stipulation testimony. It talks about using the system average as a basis for the residential rate increase. And could you kind of talk about how that compares to the methodology used in the application's rate design?
Yeah, if I remember correctly, for the application, we proposed to eliminate, I believe, 10% of the subsidy that residential receives. So therefore, the average increase for residential was greater than the system average. With the stipulation, we agreed to keep the residential at the system average.
And could you explain how the revenue increases were allocated in the stipulated residential rates to the fixed and volumetric charges? And I would say that might be better as opposed to a data request.
In generally, for the residential, we kept the increase to the basic service charge and the energy charge about the same as the system average. So we increased the basic service charge, adjusted the energy to get to the total revenues. It's not going to be the exact percentage because of the rounding of the units needed in the billing system. But in general, we adjusted the residential basic service charge and the energy charge by the same percentage.
Now I'm shifting topics again to the regulatory asset requests. Could you kind of talk about how the deferred storm damage, vegetation management, inline and well logging expenses reduce risk to both LG&E and KU and also to customers?
You're referring to the storm and veg management
Yes, the request for the deferred accounting for those.
and how it reduces
Risk.
risks. I'm not sure it reduces risk to the customer, but what it does do for the storms and veg management, it ties the two together and eliminates the need to have to file a regulatory asset request for major storms like we've done in the past several years. As significant storm events occur, we have to get approval from the commission for regulatory assets before we can record them. So it puts the commission in a bind with when the storms occur to have to rule on a proceeding for regulatory asset treatment. What we're asking for here is approval of a regulatory asset and liability for all storm cost and all vegetation management cost. It would be subject to a review after the calendar year, to where the commission can look at the storm restoration expense and vegetation management to ensure that the companies are doing the right things to ensure storm damage can be prevented, since they are linked together. So it is an efficiency benefit to the commission, and it provides more insight into how we're managing the system to avoid storm restoration costs or storm impacts. It is also tied in with all the hardening investments the companies have proposed in this case that Mr. Walder discussed. So it provides for transparency to the commission to look at both storm restoration and storm impact, along with vegetation management, and determine whether those are all prudent costs.
So for the vegetation management request, that would include the investments in the hardening of the transmission distribution systems?
No,
Okay.
it would just be the vegetation management expense. My reference to the investments in the distribution hardening is that is kind of what we're trying to do to avoid the exposure to storms.
Okay.
So
And is there,
hopefully, the intent is that these hardening investments will reduce the company's exposure to storm cost and reduce storm restoration cost. Likewise, vegetation management is a way to improve our exposure to storms.
it anticipated, I'm sorry, so what are the benefits, I know you kind of talked about the benefits, say, to the commission in terms of the way you're proposing to defer these expenses, but what are the benefits to both the utilities and the customers?
Well, again, the companies are going to invest in the system and invest in the vegetation management to ensure that we reduce our exposure to storms. The benefit to customers is that it'll reduce potential outages for customers, and reduce our exposure to the impact of extreme weather events on the system. So to the extent that we're able to reduce that exposure, that is a benefit to customers to reduce outages.
So for storm damage expenses specifically, if the stipulation is approved, what would be the amount of storm damage restoration expense that's embedded in base rates?
We can provide that exact number, but it would be whatever's in the test year for storm damage, storm restoration. Likewise, we could provide the same number for vegetation management.
Okay. And for the storm restoration expenses, is those to be recorded as a regulatory asset only to apply to like major storms, or are you proposing for all storms to be recorded as a regulatory asset?
We're proposing to include all storm damage restoration in either a regulatory asset or a regulatory liability.
Okay. And then how would the companies then define storms?
Mr. Waldrop could go into more detail on that, but it would be just any restoration expense related to storm damage.
Not just a declared emergency or major storm.
Correct.
And can you kind of talk about how the companies will effectively mitigate cost in its storm restoration activities?
I would defer that to Mr. Waldrop.
And can you kind of talk about how vegetation management expenses typically fluctuate on a yearly basis?
Again, I'd defer that to Mr. Waldrop.
Okay. So in the stipulation, there's a reduction in vegetation management expense. Is this reduction to vegetation management expense expected to then be an expense that'd be run through as a deferred asset? That 8.8 million for KU and 4.8 million for LG&E?
The reduction to the revenue requirement was a settled amount. We, to the extent that the companies will spend what they need to spend to clear vegetation. The baseline for the reg asset, reg liability will be the level embedded in base rates.
Is there any other rationale for the request to defer vegetation management expenses beyond its tie to storm management?
It is tied to storm restoration, and it gives the commission the opportunity to look at, are we maintaining our right-of-ways in a manner that will avoid impacts of storms? So I think it provides transparency to the commission to include both together. In the past, when we've had to come in for a regulatory asset request for the impact of major storms, the commission hasn't had the opportunity to look at the reasons why the storms occurred. So this gives more transparency to the commission.
So for vegetation management, for the planned on-cycle clearing, is that something that would be included in the request for a deferred asset, or is it only the off-cycle clearing that would occur as a result of, say, a storm?
It would be all vegetation management.
As a post-hearing data request, I'm still in regulatory assets, but I'm going to the depancaking. Could we just ask about the amount of depancaking expense embedded in base rates?
Yes.
Okay. And could you kind of talk about the decaking expense, like, how much control does LG&E KU really have over the cost associated with depancaking?
If I may, I'll give you a little history on the depancaking. The depancaking expense came about from our exit from MISO back in 2006. Those costs have increased, and they're tied to MISO rates, which we do not have control of. It's tied to other RTO costs, which we do not have control of. Back in 2018 rate case, when the companies were attempting through FERC to get out of depancaking, the companies and the parties agreed to a regulatory liability for the level that was embedded in base rates back then, such that if we were successful, that benefit would go back to customers in a regulatory liability. We've yet to be successful to get out from under depancaking at FERC. We still continue to try to get relieved from the provisions of that rate schedule at FERC. Those costs have gone up significantly, and that's why we're asking for symmetrical treatment in this case for a regulatory asset to the extent that those costs continue to go up. We're not successful to get out from FERC on those. So we're asking for kind of symmetrical treatment for a regulatory asset and a regulatory liability to the extent that is either greater or less than what's embedded in base rates. The stipulation provided for a reduction to the level that's embedded in the test year. That reflects the fact that we are working on it. We've got a contract with OMU for them to join MISO. That would occur in 2027. During 2026, we will still incur those costs associated with depancaking, but the establishment of regulatory asset and regulatory liability will allow that cost to be recovered for 26, and then when it goes away in 27, there would be a regulatory liability. So that provides benefit to customers.
Okay. So the amount that's been removed as part of the stipulation would, if the regulatory asset was approved, would run through the regulatory asset?
That's correct.
Okay. And then, as a post-hearing data request, could we just request the amount of well logging and inline inspection expense embedded in base rates?
There is zero embedded in base rates because we've removed that completely from the revenue requirement, and that would be recovered through deferral accounting.
If I wanted to talk about the kind of expenses occurring related to well logging and inline inspection expenses, is that something you could talk about?
You could probably ask Mr. Garrett
Okay.
first, and then Mr. Reith might be able to respond to those as well.
So in the application, there was a request for a regulatory asset to record software implementation costs associated with the IT upgrades. Is this contemplated in the stipulation?
It is not a specific line item in that, but it is part of the overall approval of everything else that's not specified in the stipulation. So yes, that is still part of the company's request.
And where in the stipulation would that be contemplated?
Should be one of the sections in the miscellaneous provisions.
I'm sorry, are you,
There is a provision in the stipulation that says unless specifically addressed in the stipulations, the parties agree that all other aspects of the company's application are reasonable and prudent.
is that in the stipulation?
I believe so.
I asking just because I did not see that provision.
Okay.
If we need a break, we could take one while
Yeah,
you
if we
look
want
for
to take a
that.
break, we can track that down.
We're right at 2 hours. We just want
That'd be
to
good.
take a break, so I don't want to interrupt your flow
Oh, no,
either,
that's
but
fine,
if
that's
that would
fine.
help. Okay, let's take 10 minutes. Ready? Oh, Mr. Crosby?
Your Honor, if I may, on this last question from staff, we've had discussions during the break, which we very much appreciate. I think there are two things with respect to the stipulation. The first is, just as you read through it and understand that it represents, that is a resolution of all the issues in the case, with absolutely respecting Sierra Club and other signatories, it was a resolution of all the issues in the case before the October 31st filing. So I want to be super clear about that. We're not suggesting that it resolves that issue at all. But everything that had been in the cases prior to that, the whole idea was that it was a resolution of all those issues. And if you read through the stipulation, you'll see that it certainly represents that from the whereases on down. It starts with the assumption, basically, that the company's applications are baseline, and then these are all the changes that the parties have agreed to make to that. Beginning with, for example, the revenue requirement starts somewhere, right? It begins with our revenue requirements as adjusted, here are adjustments we're making to that. All the other changes are to the company's applications. Admittedly, it was an oversight not to include an explicit catch-all provision at the end that restates that point explicitly. That has typically been a feature of past stipulations. It was an inadvertent oversight. During the break, we've consulted with all the stipulating parties, and if the commission would find it helpful or necessary to have that explicit representation be added to the stipulation, the stipulating parties are willing, it's my understanding, I don't want to represent anything that isn't correct, but with respect to what the stipulation covers, which is everything except the October 31st filing, that it covers, resolves all the issues in the case, and that it would start with, the company's applications are to be approved, we're requesting, with the exception of what's in the stipulation. Did I make things clearer or worse?
No.
Let me try it.
Mr. Grumman?
Please.
Your Honor, as a stipulating party, I will tell you what my understanding was, and I'm going to do so without attempting to disclose confidential communications. I have read the settlement testimony, which contains the language of, except as modified in the settlement, everything from the company's application is accepted. I did not object to that testimony because that was consistent with my understanding in the stipulation.
Okay.
I, in fact, when they came over to me and said it wasn't in there, and I was like, no, yes, it was, because that's what I agreed to. I do believe a term of that nature to have been a term that was exchanged among the parties as we reached agreement. I viewed its exclusion from the actual document itself that was filed with this commission, I viewed it more as a Scrivener's error, because I believe that to have been what was agreed to, and I will only speak on behalf of Walmart as the signatory. But when I saw it in the testimony, it didn't, if I had thought it was inappropriate, you would have seen an objection as you saw other parties filed objections to things that were filed. That's because I do believe that to have been the scope of the agreement.
Yeah. I did ask that as one of the overall questions. I won't tell you whether you need to amend your stipulation agreement or not. But if that's an amendment that the parties feel like they need, they could obviously do that.
Thank you, Your Honor.
Back to staff questions.
Okay, so let's switch topics to the CSR rates. I was just curious if LG&E KU had conversations with the CSR 1 or 2 customers about the increase in rates and penalties by 40%.
The increase in the CSR rate was a product of the stipulation in totality, which included the KIEC, AG, and other representatives. We did not have specific conversations with individual customers during that settlement.
Oh, I meant like after the fact, so after the stipulation came out, were there any conversations with the CSR 1 and 2 customers at this potential increase or penalties?
I'm not aware of any specific conversations with customers at this point.
So for the green tariff rider, could you refer to the stipulation provision that would modify the green tariff to make option 3 available to rate PS customers, as long as the rate design proposed by the stipulation is approved?
Do you recall which section that is?
Let me see. I think it's in the miscellaneous provision. Yes, it's 9.5.
Okay.
Could you explain why option number 3 is not currently available to rate PS customers?
When green tariff was originally offered, we didn't include PS in that. PS at the time was a single demand rate, summer, winter differential. It was smaller customers, so it just wasn't included. At this point, we're agreeing to include PS customers and give them the ability to participate in the green tariff.
So there wasn't any specific reason, essentially, why it wasn't originally included?
Not that I recall from
Okay.
the case that we proposed that.
And can you kind of explain why the rate design proposed by the stipulation has to be approved in order for option number 3 to be available to rate PS customers?
What we're proposing on the PS is to make it a three time period, time differentiated rate consistent with the other rate schedules. Again, those other rate schedules have the structure. We just believe that if we're going to include PS, we want them all to be on similar rate structures.
Okay. And I was wondering, as a post-hearing data request, so with the stipulation, you filed tariff sheets that were a red line of your proposed tariff, correct?
Correct.
We were wondering if you could do a red line tariff from the currently approved tariff as to reflect all of the changes proposed by the stipulation. So the red line would include both the stipulation proposals and then, if not otherwise specified by the stipulation, the ones that are approved by the stipulation from the application. Does that make sense?
So just to be clear, you're wanting a red line that includes all changes proposed in the application as well as the stipulation.
Basically, we want a red line tariff of the current tariff for all proposals in total that the stipulating parties are putting forward to be approved by the commission.
So when you say current tariff, are you meaning the ones that are in effect today?
Yes, the current in effect.
That may reflect changes that have occurred since the company's application through other proceedings?
Yeah, so,
Okay.
yeah, I think that probably would make the most sense, the current approved tariff and then just.
Yeah,
change.
there are things that have changed in the tariffs outside of the base rate case application, and there will likely be other changes that occur before the commission's order in this case that ultimately would need to be reflected in the tariffs that would be filed at the conclusion of this case. So we can identify those as well.
Okay, that sounds good, thank you. So now I'm shifting topics to kind of some of the questions about the ROE. Could you kind of explain the reasoning for the allowance of a 9.9 ROE through all the mechanisms, excluding the DSM cost recovery?
As part of the stipulation, all parties agreed that 9.9 was a reasonable ROE at this point in time for all the mechanisms. The DSM mechanism itself starts with the base rate ROE, and there is a 50 basis point adder incentive that has been applied for that mechanism. So we would make that same 50 basis point adjustment in the DSM for that.
And if there's any other cost tracking recovery mechanisms that were approved after the rates go into effect in this case, but before the next base rate case, the 9.9 ROE would apply to those as well, correct?
I would assume that we would address that in any other proceeding and adopt whatever was approved in the most recent rate case.
Okay, so it wouldn't be an automatic that the 9.9 ROE would go towards all mechanisms?
Yes.
Okay. And could you provide as a post-hearing data request just a list of all the mechanisms for which the stipulated base rate ROE would apply for both gas and electric, for both, well, I guess, yeah, for KU Electric, LG&E Electric, and LG&E Gas?
Yeah, we can provide that, but currently for electric, it's the ECR mechanism. For gas, it's the gas line tracker, and then it would be the mechanisms that come out of this proceeding.
And could you kind of discuss how the proposed adjustment clause GCR and adjustment clause SM affect the risk that LG&E KU would be assuming due to the stay out compared to if they entered into a stay out commitment without the proposed adjustment clauses?
Yes, as the commission is aware and what's in this proceeding, there are significant investments, not just in the generation system, but also in transmission, distribution, and IT. Those are significant investments that the companies believe are necessary to continue to provide safe and reliable service. Absent the stay out, it would be very difficult for the companies not to come back in for a rate case because of the significant investments in generation and the other parts of the system. So they work in tandem, and they are critical for the company's ability to maintain their financial integrity and not file rate cases to adjust rates to recover the cost of those significant investments.
And my next topic I have is relate to the EHLF tariff. So if a new customer with a 50 megawatt load and 85% load factor were to locate to LG&E or KU service territory, if approved in this case, that customer would become an EHLF customer, correct?
Correct.
Is there a reason that this wasn't limited to data centers specifically?
There was no reason to point out data center specifically. It is a high load factor tariff that would apply to any large customer that has a high load factor. It was anticipated that that would typically be a large data center.
And the only two criteria in terms of who would be under this tariff is just that 50 megawatt load and the 85% load factor, correct?
The availability section talks about the size and the load factor. There are other provisions that that customer would have to accept, that being signing a 15-year contract, putting up collateral that is significant, and being subject to 15 years of a minimum demand charge.
And if a customer would not agree to sign onto those commitments, would they still be served under a separate class?
If they meet the criteria of the load and the load factor, we would serve them under EHLF.
Okay. And could you kind of explain a little bit more what was meant by a customer attempting to circumvent the minimum capacity threshold? For example, if there's a new HL customer with 50 megawatts of load were to locate 25 megawatts in KU service territory and say 25 in LG&E's, would that customer be served under EHLF?
That would be two different customers. So the intention was if at a single site, they attempted to include 20 megawatts for one building, 20 megawatts for another building, and so forth, to avoid being under the threshold. That's what it's intended to cover. Again, as I mentioned yesterday, this is a retail transmission, so they're served at transmission voltage, and there would be the requirement for that customer to have and pay for a transmission substation to serve that load. So it's a significant investment for the individual customer.
And I believe in case 2545, we talked a little bit about, it's unlikely that a developer would end up being the ultimate person to sign the electric service contract, is that correct?
Most likely so, correct.
And so it'd be more likely to be an individual, like tenant for, like, to sign that contract.
Most likely, but I think Mr. Bevington could probably address that more specifically.
Okay. I'm gonna ask my next question, but if it's for Mr. Bevington, just let me know. So if we have a situation where there's the same type of data center campus, and there's two separate customers who've each signed their own electric service contract, let's say 25 megawatts and 25 megawatts, would they qualify under the EHLF tariff?
If they are two separate entities, then no.
Okay. So, but for the stipulation requiring that the rate EHLF tariff only be applied to new qualifying customers, how many current customers would potentially be under this EHLF tariff with the move from 50 MVA to, 100 MVA to 50 MVA? So I believe somewhere in the testimony it talked about one current customer probably would qualify except for that provision saying it only applies to new customers, or any other customers other than the stipulation provision, would they qualify under EHLF with that decrease?
We would have to look at that as a
Okay.
post-hearing data
Okay.
request specifically.
So post-hearing data.
It would not be anticipated that there are very many customers, if any, that have a load factor that high.
And could you explain how the maximum load charge per KVA was KVA was calculated?
What do you mean? The rate itself that's in the tariff? It is equivalent to the demand charges for RTS. RTS is a single, or is a 3 time period rate. EHLF is a single rate that is equivalent to the summation of the RTS demand rates.
And as a post-hearing data request, could we just ask for the work papers that kind of explain what you just talked about how the rate's calculated?
Yes.
So since the rate EHLF contains a basic customer charge, energy, and demand charge, is it possible for different negotiated rates to be included in the customer's electric service contract?
If they are served under a standard rate, they would be under the provisions of that tariff. We would only use special contracts if the parameters didn't apply or were different. We don't anticipate serving the customer under any customers under a special contract, so therefore the rates that are in that tariff is what the customer would be charged.
And does the LG and EKU feel confident it will be able to average costs across all customers taking service under this tariff?
What do you mean, average cost?
So if there's, say, a 500 megawatt customer versus a 50 megawatt customer, if it makes sense to average those costs. Kind of in another way, is the customer similarly situated so the average cost would be reasonable for all of them, like the average rate?
Given that the EHLF is for loads that are greater than 85%, your average load factor and demand is probably going to be pretty consistent across those schedules. That's particularly why we have a separate schedule for them, because trying to serve something like that under RTS, which has a system average of about 65%, would not necessarily be appropriate.
And for the EHLF customers, is it going to be a standard electric service agreement or will it be a special contract?
Again, they will be served under the EHLF tariff. For all large customers, there is a standard electric service contract that's signed. It's not a special contract, but the companies have agreed that we would file those with the commission, so they know who's being served under those, but it's just a standard contract for service.
And now I'm shifting away from the stipulation to your rebuttal testimony at page 7.
Okay?
So it's kind of about you addressing Mr. Collins' comments regarding off-system sales. And as the final order in 2545 has gone out kind of since your rebuttal testimony, could you kind of explain the costs and benefits of a change in the sharing allocation as recommended by Mr. Collins if the load doesn't materialize?
Not sure I follow your question.
So I think in Mr. Collins' testimony, I think he recommended an increase to the off-system sales, correct?
Yeah, Mr. Collar recommended actually 100% to customers and 0 to the companies.
And basically, if the load kind of, that the companies talked about and that the commission talked about, it's 25, 45 order, if that load doesn't materialize, would there be benefits to a change in the sharing allocation?
To the extent that we're able to make more off-system sales, the customers still get the benefit of 75% of the margins on off-system sales. So yeah, there's always a benefit to customers for the company's ability to make off-system sales.
And if the load doesn't materialize, would you consider that a changed circumstance?
Change circumstance compared to what?
So changed circumstance, if you look at your rebuttal testimony, that was a term that you used, so kind of what you were talking about in your testimony.
What I was referring to there is when the companies and the parties to the previous case, I believe it was 2014 or 16, when we agreed to remove all off-system sales from base rates and share that 25 between customers and companies. Nothing's really changed on the system that would change the logic behind that agreement. That's what I was referring to.
So if so with the approval of the new generation assets, if the data centers and other economic development load doesn't come after new generation is built, would that be considered a change in circumstance?
I would not consider that a change in circumstances. I mean, we're going to utilize the assets however we need to and make off-system sales for the benefit of customers.
And I'm looking at your rebuttal testimony at page 15 to 16. Related to like net metering and LG&EKU's methodology.
Yes.
Do you define LG&EKU's methodology for net metering as instantaneous?
We do not use the term instantaneous. We follow the statute on the methodology for net metering. And we measure the flow of electrons back to the company and the flow of electrons to the customer, and we compensate at the agreed upon rate times that energy.
And are you able, and this is shifting topics a little bit again, are you able to speak on the rules for retail electric service studies and related implementation costs that was proposed?
What specifically are you referring to?
I guess first, like, could you provide us with a brief overview of that proposed tariff?
Oh, you're referring to the tariff.
Yes.
I would defer to either Ms. McFarland or Mr. Horning on the specifics of the tariff.
And I'm getting towards my last couple questions. Has LG&EKU studied whether to standardize using either AFUDC or CWIP to recover working capital, but not using both?
You're getting into an accounting area, and I would defer to Mr. Garrett on that discussion.
And then the last question I have is just back to the sharing mechanism. So the October 1st filing for the November rates, I know kind of earlier, I think yesterday in your testimony, you kind of mentioned that the filing would be similar to the filings of a rate case. Would that take the same format as like the schedules A through N in this case?
I think if you look at what we filed Friday, we tried to replicate what kind of forms that would be filed with that SBM. It does include some of the similar schedules, A through certain ones, G, not specifically. I don't recall exactly which ones. But again, these are what we believe should be appropriate. We're always open to discussion with the staff on what may or may not be better for the future.
And thank you, that's all the questions I have.
Okay.
Mr. Wood?
Yeah. Good morning,
Good morning.
Mr. Conroy. I was going to ask Mr. Schramm who had the toughest job at KU because the forecasting future load, but I think after our last 2 days, I think you have the toughest job at KU.
Yeah, that's always debatable, who has the toughest job in the company.
I wanted to ask sort of from a 50,000-foot view, how the companies were thinking about or justifying the requested return on equity of 10.95%.
I mean, we rely on our ROE expert in the various methodologies. So I would defer to Mr. Diascendis on those methodologies. So we believe that it is appropriate to rely on the experts on those.
Do you know how that would play or how that would compare with other vertically integrated utilities, the 10.95?
I think if you look across a lot of the applications from the different companies, that's in the range of what is appropriately found. I believe there's been numerous cases in Kentucky already this year and last year. Those requests were in the upper tens.
And that's just the requested or the awarded?
Those were the requested.
I wanted to ask you too about the the stipulation amounting to an increase in return on equity to 9.9%. What is the current ROE for the companies?
The current awarded in the last rate case in 2021 was 9.425.
And so this would amount to an increase of 0.5% or so?
Correct.
It also seems to me from the stipulations and the, I guess the GCR adjustment clause that it would, that basically the companies would be guaranteed no lower than, is it 9.4% as the bottom?
For the sharing mechanism, yeah, that it is a asymmetrical deadband for that mechanism. So anything between 9.4 and 10.15, there'd be no adjustments.
It seems to me like that sort of decreases the financial risk to the company, though, to set that floor. Is that correct? Is that
Sorry, did you say increase or decrease?
it decreases the financial risk to the companies to have a floor of 9.4%?
Well, the companies still are exposed to be able to earn the 9.9 that's agreed to in the stipulation. So, I mean, there is still some financial exposure to the company.
And how so? How would you describe that?
Given that the sharing mechanism goes down to 9.4, we're exposed to ability to earn between 9.4 and 9.9.
But the current ROE is 9.4 or 9.44, did you say?
9.425, but there's been a lot of changes in the marketplace since that stipulation. I believe Mr. Diascendis, I can't do that, could explain more of the changes. And again, ROEs have been increasing since the company's stay out.
Since the what?
The company's last day out.
That's all the questions I have, Chair.
Okay. Commissioner Regan?
I have two quick questions so we can get you off this thing
For lunch?
What do you think are the biggest risks you see over the next 2 to 5 years that could impact the assumptions in the stipulation? And how have those risks been assigned?
I would say some of the biggest risk is the need for the significant investments the companies have forth on transmission and distribution and IT. There's a lot going on in maintaining the system and hardening the system to ensure that we can continue to provide safe and reliable service to all customers. So I would say that's a pretty significant risk to the company. Load growth, there's a tremendous amount of push in the Commonwealth to attract economic development to the state. As we put forth in the CPCN, we want to make sure that we have the ability to serve all customers that are coming to the Commonwealth. That can be a big challenge given the time frame for generation and investments in transmission system relative to what customers may desire to receive service. So those, I would say, are some of the two biggest risks.
And if the data centers don't materialize, are we looking at stranded assets?
I would not call them stranded assets. I believe there's more economic development throughout the state other than data centers. We've got existing customers that are growing. We've got other manufacturing customers that are being attracted to the state. You have all the push to onshore manufacturing to the U.S. that I believe will drive more economic development in the United States.
Okay, so.
So I think it's
we've
more
been-
than just
Just the
data
data centers?
Yes.
Okay, that seems to be the topic, but I'm not sure that's all the economic development that's in the pipeline. Is that correct?
That's correct, and Mr. Bevington can talk extensively on what he's seeing for economic development.
From your regulatory perspective and your background, how are you going to measure whether or not stipulation is successful? Are you going to have success metrics in the company?
No, I think whether it's successful will be dependent upon how financially sound the companies can be during the stay-out period. We will continue to invest in our systems to adequately serve customers. So I think the measures are on our continued operation as a well-run company. I think historically we've done a very good job at maintaining our cost for customers and providing significant investments and the ability to continue to serve all customers.
And in the stipulation discussions that you've had with everyone, was there discussion on how we would measure these things?
Not specifically, no.
Okay.
I mean, the discussion centered around the stay out and the criticality of the two mechanisms for our ability to stay out. Those two mechanisms are very critical because of the significant investments that we're making.
Okay, thank you.
All right. I won't belabor either. You've been testifying quite a while. So just some general and specifics. Regarding the storm and vegetation deferral, would you say that that qualifies as a tracker? Is it the same thing as a tracker?
I would not call that a tracker because it is deferral accounting, and it is still subject to commission review. There's no guarantee of cost recovery. While we'll record regulatory assets or regulatory liabilities, it is still subject to the commission review on those costs and whether those costs could be recovered in a future rate case. So I wouldn't consider it a tracker itself. It is different than the generation cost recovery, ECR, which I would consider trackers.
It was modeled after the ECR,
The
GCR.
the GCR and Mill Creek 2 were modeled after the environmental cost recovery mechanism that's been around for a long time.
So staff asked you some questions about, why include routine vegetation management, and, roll that in with storm damage. I see the reasons you would want to do with storm damage, and how that would reduce exposure, but the planned on-cycle vegetation management. What's the rationale for including that? I mean, it seems like a very planned and predictable cost for the utility.
The intent was just to include all vegetation management, which, I mean, there's a level embedded in base rates. In the deferral account, if we don't spend everything, or don't need to spend everything, then there'll be a regulatory liability. If we believe we need to spend more in order to avoid storm restoration costs, we'll do that. Mr. Waldrop could talk more about their vegetation management programs in detail.
I can ask him some more questions about that, but do you know if you're meeting your goals for clearing vegetation?
As far as the cycle, I believe so, but he can give you the details on that.
So you get quicker and almost perfect recovery for those storm damage or vegetation management expenses. But then you'd also, under this stipulation, earn the 9.9% ROE on that.
I wouldn't say we get quicker recovery because it's deferral accounting. It's going to be recorded to a reg asset or a reg liability, and it'll be addressed in the future for recovery. So I wouldn't say there's quicker recovery. It's just in the accounting process. And Mr. Garrett can talk more about the return on regulatory assets and liabilities.
And also for the in-line inspection and well logging expense, is there a better witness to ask about those things?
Yeah, but you could talk to Mr. Garrett and Mr. Reith. Sorry.
I was going to ask you some questions about the lack of a catch-all phrase in the stipulation, but I think I'll leave that for lawyers to decide what it means and whether it's needed.
That would be fine.
I really think that's it for me. I think the staff did a great job and everybody else. Redirect.
No redirect.
No redirect. All right. In that case, no recross. We're not going to excuse you, sir, but you can sure finally get off that stage.
Thank you very much.
All right. And we've got 10 minutes till 12. I think it might make a lot more sense to do our lunch break from 11:50 to 12:50
Okay.
instead of starting a new one.
And our next witness is Mr. Spanos. I don't have any idea what level of questioning exists for him, but if it makes sense to break now, that's what we'll do.
This bunch, I'd say.
Fair enough.
All right, thank you. We'll be in recess for an hour. All right, good afternoon. We are back on the record in cases 2025-000-113 and 2025-000-113. And applicant, please call your next witness.
Next witness, Mr. John Spanos. Ms. Wimberly will present you.
Mr. Stannis, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Tell us your full name and business address, please.
John J. Spanos, 300 Sterling Parkway, Mechanicsburg, Pennsylvania, 17050.
Counsel?
Good afternoon, Mr. Stannis.
Good afternoon.
Would you please state your employer and job title for the record?
I'm employed by Gator Fleming Valuation Rate Consultants, LLC, and I am the president.
Did you cause to be filed in these proceedings direct and rebuttal testimony?
Yes, I did.
Did you also sponsor responses to certain data requests in these proceedings?
Yes, I have.
Do you have any corrections to that testimony or those responses?
No, I do not.
The witness is available for cross-run.
Okay. And for the Attorney General's office?
No questions.
For KIEC?
No questions.
For Sierra Club?
No questions, Your Honor.
For KYSEIA?
No questions, Your Honor.
Joint interveners?
No questions.
Walmart?
No questions, Your Honor.
KBCA?
No questions.
Kroger?
No questions.
Louisville and Lexington?
No questions.
All right, staff.
Oh, no. I don't want to be the only one with questions, but I do have a few. Mr. Spanos, if you are unable to hear me or the question would be better asked to somebody at the company, if you'd just let me know who that might be, I would appreciate it.
Sure.
Okay, so my questions are a little more hypothetical in the beginning. Could you talk, or just your philosophy more than anything, could you talk a little bit about what the benefits are to, if any, removing terminal net salvage value for the thermal generating units from the requested revenue requirement?
The only benefit that I see in removing it is that the exact amount is not known. It is my opinion that terminal net salvage is a critical component for generating units because the full definition is to recover the full service value of every asset, which includes cost of removal, decommissioning, and gross salvage. So in order to do that over the life of the asset, you need to have that component as part of your recovery pattern. However, if the estimates that are available to us aren't specifically known, that would be the only reason to do it, but it's not something that you could wait a long period of time. And these assets have been in service for a while and have had that component as part of the recovery to date.
So, and I know you've kind of touched on it there at the end, but could you talk a little bit about the disadvantage of removing it? I know you mentioned since they have had it in the past until recently, but are there other pitfalls that might exist or occur from removing the terminal net salvage?
Well, the disadvantage, again, as I mentioned, is just not getting the recovery while the asset is being utilized. So you don't have the full recovery in a systematic and rational manner, which is the desired way to recover the value of all your assets. So that's the disadvantage. Again, if it's a short-term scenario, then you're able to recoup those without harming anybody.
When you, I'm going to shift a little bit. When you are doing your evaluation regarding the depreciation rates and that type of thing, can you discuss the benefit of evaluating each unit individually versus maybe like the Mill Creek station as a whole station, even though it has individual generating units? Does that make sense? Like,
Are you asking evaluating a probable retirement date? Or are you asking more of a terminal net salvage component.
The probable retirement dates.
Each unit has their own expected life, how they're being operated. So to recover the investment, again, based on how long they're going to be utilized, based on the efficiencies, the costs, when the overhauls occur, all of those things are built into the most appropriate probable retirement date that's estimated. So each unit will have one has a different age, how it's called into utilization, because these are not all base load units, some are load driven. So you have a different amount of utilization of each unit within the entire system. So because of that, you'll have different life characteristics, and that would be why you'd want to recover the investments on a unit-by-unit basis.
So I guess maybe if you could give me a few more examples. You mentioned that utilization might reduce a unit's life expectancy. What are some of the things, is there anything else that, similar to that, might reduce the useful life of a unit faster than one that was built around the same time?
Environmental regulations will have an effect on each unit in some regard. When you do overhauls, you find wear and tear on a specific unit, and the cost of effectively or to refurbish that unit may not be a wise decision. So you would then retire the unit if you had some heavy cost in order to bring that in. Age has a factor. Those are all kind of the primary characteristics that would drive a retirement date or the need. Again, how much those particular units are needed to meet the demand. And maybe one of them isn't as efficient, and so that would be a reason not to call it into use as often, which in turn then may not be a requirement going forward.
My last question relates to the NGCCs that were recently approved by the commission in 2545. I know that you looked at, you've done a lot of depreciation studies. So based on the fact that those are larger NGCCs, do you foresee any particular issues with their useful life being 45 years? I believe that was the recommended useful life in this case, or mentioned in this case for those.
There's not a exact date that is ideal for every unit. They all are driven by the number of starts, how they're being utilized, how often they run, as far as whether they run for 3 hours, 5 hours, 3 days, etc. Then you have the overhauls that are required to go through a usually 24,000 hour or 25,000 hour cycle. Then you have another one at the 48 or 50,000. So how you achieve those time periods and the utilization kind of drives the overall life. And what we have found in the industry to date is 40 years is the most common period of time that all of those factors come into play. Does that mean that 45 is not appropriate? No, it's a reasonable expectation. In my view, 40 was the most appropriate based on all of those factors that I brought up and how they were going to be utilized. So I wouldn't say that size necessarily is as much a factor as the number of starts, hours utilized, what's required during the overhauls. Those are things that are drivers for the life characteristic of those assets.
That's all I have. Thank you.
Okay.
I don't have any questions.
I don't have questions either. Redirect.
No reason.
Sorry. Sorry, I was looking at the wrong lawyer. All right. Any reason this witness can't be excused? All right, you're excused, sir. Thank you.
Thank you.
And whichever one of you is going next, call your next witness.
Yes, our next witness, Your Honor, is Dylan Diascendis, and Ms. Braun is going to present him.
Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have tell us your full name and business.
My name is Dylan, D-Y-L-A-N, D'Ascendis, D''ACENDIS, and my business address is 1820 Chapel Avenue West, Cherry Hill, New Jersey, 08003.
Counsel?
Can you please provide your employer and job title?
Yes, I'm employed by Scott Madden, Inc., and I'm a partner there.
And Mr. D'Ascendis, did you file direct and rebuttal testimony in these cases?
I did.
And were you also the sponsor of certain data responses that were filed in these cases?
I was.
Do you have any changes or corrections to your direct or rebuttal testimony?
I don't.
Do you have any changes to any of those data responses for which you were the witness?
I don't.
The witness is available for cross-examination.
Okay, for the Attorney General's office?
No questions, Chair.
AIUC?
No question.
Sierra Club?
No question, Your Honor.
KYSEIA?
No question, Your Honor.
Joint Intervenors? Walmart?
No questions.
KBCA?
No questions.
Kroger?
No questions.
Louisville and Lexington?
No questions.
Staff?
We do have questions.
Okay.
Mr. D'Ascendis, I want to ask you a few questions with regard to your proxy group selection, notwithstanding the proposed stipulation. In your rebuttal testimony at page 4, you updated your gas and electric proxy groups using the 2024 fiscal data year. I don't know if you want to pull that up or not, take a look at that. Your update resulted in the inclusion of Chesapeake Utilities Corporation in your natural gas proxy group, as it now meets your screening criteria. Can you elaborate what you meant by "as it now meets your screening criteria"?
Yes, sure. So if you go to my direct testimony and go to section 4, oh, yeah. Scroll down a little bit. So if you're looking at go down to the bottom of that page, there it was. Page 13 and 14, that's electric, and then you'll see gas after that. Go down a little bit more. Sorry. I think this is still electric. Yeah, you can keep going down. So this is the gas proxy group here.
What page are you looking at now?
This is page 15, sir.
15?
So Chesapeake, using the 2024 fiscal year data from their 10K, passes all of these criteria. So last year in 2023, they failed criteria 2, and now they pass criteria 2. So they have 60% or greater a fiscal year, and this would be 2024 operating income derived from, and 60% or greater total assets attributable to regulated natural gas operations. So that was why they now pass.
Okay. So the company itself changed with regard to 2. Equally, with regard to Northwestern Corporation, you stated that this update resulted in the exclusion of Northwestern Corporation from your electric utility proxy group, as it no longer met your screening criteria based on the percentage of operating income and assets from regulated electric operations. Can you elaborate on that as well?
It's the same now. Now, if you scroll back up to 13 and 14 of my direct, that has a higher bogey. It's 70% because it has a larger pool to draw from. But Northwestern no longer hits that 70% mark, given given 2024 operating data. We could provide that to you, the selection criteria for the 2024 if you need it.
Yeah, that would be good. Could we get that in the post-hearing data request?
Absolutely.
I want to ask you about some of your adjustments. In table 1 of your direct testimony, I believe that's on page 4 if I'm not mistaken, you applied a size adjustment of 0.15% to gas proxy groups. Is that correct?
Yes, sir.
And what empirical evidence supports the specific 0.15% figure?
The 0.15 is a judgment figure, but the studies are based on the Kroll study, the Kroll size study, which would be in section 8A in my direct testimony. I don't know if I can control it, but, and then it would be scheduled. You could keep rolling down. Keep going. So these are all, so right here, if you look at page 51 and 52 of that schedule, you're looking at, these are the relative sizes. So relative sizes of the electric and gas proxy groups as compared to LG&E. And then you have KU as well. So they're multiples smaller than the proxy group. And then if you scroll down a little bit more, if you're looking at, once you look at that, and these are all on the, if you take can you get to schedule DWD one, or get to the schedule?
You're looking at the top of page 53?
Yes, but it'd be 53, but if you look at 11, I think. No, 9. Keep going up. 8. Sorry. Here it is. DWD 8 has the study from Kroll and the indicated size premium from Kroll. So each one of the estimated market capitalizations for KU and LG's gas and electric operations, that's on the leftmost column there. And each one of them falls into one of 10 deciles. And the studies that were quoted in section 8A of my direct testimony, these kind of back up the proposition that all else equals, size and risks are linked for utility companies. Now, when you pull these into these size deciles, you get a given return premium. So if you look on column 3 of exhibit DWD 8, you have the applicable size premium for not only the 3 companies here, so KU and LG&E, but you have the electric companies and the gas companies. And it looks like C doesn't have, it must have wrapped around, but 2C is the proxy group of the gas companies. So when you take a look at and you compare the company's applicable size premium and the proxy group's applicable size premium, you get an indicated size premium. And that's where I get the bogey from which I select my recommended adjustment for size.
Is there any way we could actually get that data?
You should have it from in our work papers, but I could check.
Okay. All right, thank you. I also want to ask, you added a flotation cost adjustment of 0.15%. Did you verify that LG&E and KU actually plan to issue new equity?
Well, LG&E and KU don't issue equity because they're not publicly traded stocks, but PPL would issue equity. The issue is that flotation costs are permanent in nature. So when you issue equity and you have to pay to float that equity, you have to forgo investment in something else. So say if you issue $1 million worth of equity and you have to pay $50,000 in flotation costs, that no longer can be invested in plant, property, and equipment to serve the customers. So that expense going forward is lost to be recovered, because since it's permanent in nature, the plant, property, and equipment, and the ongoing operations of the company, you're always going to have less than what you were supposed to have, with the absence of flotation costs. Now, if you look at Schedule 9, the next schedule here, this shows a hypothetical example on flotation cost recovery. So if you look at this, you see that you're getting if you don't get flotation cost recovery, you're actually earning less than what you're going to get. So when you're putting in flotation costs in your ROE, you're actually recovering the cost of your capital for that entire investment. So it's more of a permanent thing. You don't really need to have an upcoming issuance to have costs, because those costs go forward from your initial issuance of equity.
Based on your testimony in previous cases, you are aware that the Kentucky Public Service Commission does not agree with adding flotation costs.
I do agree that that is their stance. I would note that a lot of these models that we talk about, so the DCF, the CAPM, the risk premium model, none of them account for transaction costs or flotation costs. So when you're going through those things, the cost of issuing that equity it's not accounted for in those models. I think Mr. Baldino makes that argument, and it's just not true.
Let me ask you, since you brought it up, on page 51 of your testimony, you stated that LG&E and KU's small size relative to the utility proxy group companies indicates greater relative business risks for the companies because, all else being equal, size has a material bearing on risk.
Yes, sir.
Is that correct? But as you said, given that LG&E and KU are subsidiaries of PPL, which is a much larger, well-established, capitalized parent, would you agree that their financial risk is actually lower than a standalone utility?
I would say that PPL is lower risk than a standalone utility because they have a portfolio effect. But when you're looking at these companies that the Kentucky Commission is setting rates on, so if you're looking at KU and you're looking at LG&E, these need to be evaluated on their own risks facing them. The portfolio effect doesn't apply to single companies. Now, because you have to set rates for this company alone, you have to reflect all the risks facing that company. So I agree that PPL, through them holding utilities in Rhode Island and PA and Kentucky, that insulates them from risks from the other parts of their company. But KU and LG&E, they don't have that level of diversification. They are subject to the geographic limitations. They're subject to the customer base here. They're subject to the weather here. So when you're looking at KU and LG&E, all their eggs are in one basket, and that risk has to be reflected in the ROE.
So you would not agree that parental support from PPL would reduce the risk?
Not entirely. I think that I've given consideration in my recommended size adjustment for those types of things. I don't take the full size adjustment indicated in DWD 8, for example, to reflect some of those mitigating factors.
I want to ask you one other question with regard to the current climate. Would you agree that customer costs and affordability are of particular concern today?
They might be, but it wouldn't be covered in, I guess, the ROE is reflected, it reflects current and expected capital markets. So whether the overtone is, prices are too high or whatever, those would be reflected in market prices that we use to determine our models. So anything that has to do with affordability and the climate, as far as the cost of capital analysis is concerned, that would be all reflected in market prices. Any type of reduction due to affordability, I think, is not appropriate, because we're looking for investor required return. It's not particularly. This is what the investor is requiring to put money down, but we're making an allowance for something else. I think the affordability aspect's better addressed in policy and some other things company-wide.
So I have a couple of questions that were directed to Mr. Conroy, and he passed the ball to you. And this is with regard to the stipulated ROE, I'm sorry. Can you explain the 9.9% ROE for assets being recovered through the rider?
So are you asking about how they got to the 9.9, or what the 9.9 is applied to?
They're asking what the 9.9 is applied to with regard to the assets being recovered through the rider.
Okay. And let me know if I'm not answering the question that you asked, but generally, are you asking why the ROE is the same for the base rates and for the riders? Is that what you're asking?
Yes.
Okay. Well, there's a couple things on that. And the first thing I think Mr. Conroy said, the 9.9 ROE for both the riders and the base rates was an agreed to and negotiated piece of the settlement. So that's just one piece there. The second piece is, if you're looking at it, and this is in my testimony on pages 66 to 68, but we'll get there a little bit later. When you're looking at risk and return, and you're looking at the assets, these riders are infrastructure riders, and generally infrastructure riders. And you have to get the return for the risk of your investment. Both assets, so base rate assets and rider assets, both have the same risk of electric and gas service. So there is no difference in risk when it comes to the function of those assets, generally. And then when we're talking about, I know there was a specific question about risk and if it lowers the risk of the companies having these riders. That's more of a question of relative risk analysis. So generally, you have the riders, you're able to recover them faster because you're not waiting for a rate case to put it in service and get the revenues back. You would have to take a look at your proxy group companies. So, and I did that on Schedule DWD 12 in my direct testimony. And it's a bit of an eye chart. But when so after, that's fine. So you have the third column is the capital investment trackers. And those are for all of the proxy group companies and their operating subsidiaries companies. You can see that there's a bunch of check marks there. So if there was any risk reduction with the implementation of those type of capital trackers, they would already be reflected in the market data of the proxy group companies that we've used to calculate the ROE. So that's probably the easiest way to talk about that. You have the capital investment trackers. They're known and used and looked at by the market as they have these or they don't have these. And in any type of risk mitigation, which I don't think there are, but generally if there is any type of risk reduction with that, it's already backed into that type of that rider. And then I think Commissioner Wood said something about the deadband, and if I can go with that. That would be, so that deadband, that earnings sharing mechanism, that's akin to the decoupling piece, which is the first column. And that is where, you're looking at these companies, it's reflected not as much as capital investment trackers, but they are reflected, in which means that they would be reflected in the market prices and the market data. Another thing that I would note on this particular thing is that the sharing mechanism is a temporary piece for that 13-month period, then it goes away. So these, on the other hand, are permanent. These ones are going permanently. So they're reflected already in the prices. And you're looking at, 13 months of the deadband that you have just so that the company can basically stay whole during the stay out.
Can you explain whether this mechanism would present less risk to shareholders than base rate recovery?
I think I already went over it, but it's more of a relative risk argument. If the mechanisms are present in the market data of the companies that we're using to select or using to calculate the ROE, then there wouldn't be any excess risk mitigation based on the implementation of the riders.
If there are similar risks, can you provide examples of the risks of running these assets through a rider?
I don't know. I'm not an accountant, so I don't know that. I guess could you ask it a different way?
You can give us a minute.
Sure.
That's all we've got. Thank you.
Thank you.
Okay, Commissioner Wood?
Yeah, I'll take a stab at a couple of questions. And I'm going to ask about return on equity as well, and I guess the reasons for it and the reasons behind adjusting it and things like that. And if the commission were to grant or award 10.95%, I think that would be an increase of about 11% in the return on equity in the neighborhood of what it is now. And And I'm just wondering, is there a need for that? Does the company show, or do the companies show a need for increase in ROE in order to attract capital going forward?
Sure. So I'll start with what I said to staff, and the ROE reflects current and expected market conditions, right? So the last, and we'll go back to the last authorized return for the company, which was 9.43, give or take a couple basis points. Back then, interest rates were approximately 2%. They have doubled and then some since then, right? So the capital costs, which are the base of a lot of your equity models, so the risk premium uses an interest rate, so does the risk premium. They both use interest rates. And that base risk-free rate has doubled since the last rate case. The settlement ROE in this case, which I guess is what you guys are going to rule on, is 9.9%, which is approximately 50 basis points higher than what they were authorized. So when you're looking at the movement in interest rates and some of the things there, you could say that 9.9% is a conservative number based on some of the changes in economic conditions from the last case. As far as my models and modeling went, we use the market data and we apply them to commonly used models, the capital asset pricing model, the risk premium model, the discounted cash flow model, all of which were used by the intervening witnesses in this case. We had different inputs. We have different opinions on which ones are the best. I think mine are better, obviously. But the settling parties, they were able to find agreement in the middle, right? So I had the low end of my range was approximated the high end of that deadband, around 10.15. And then the other witnesses fell in line between that 9.40 up to that 10.15. And I feel like because of that, all of those points and ROEs and analysis seems to support the record of that 9.9 as an agreed to figure. If we were fully litigating this thing, I would say that my 10.95 is better and my inputs are better and their inputs aren't as good as mine. But in this case, because they agreed on all these issues and this is a package deal and they have the stay out and they have the riders, it's a reasonable agreement to a complicated case, to paraphrase what Mr. Conroy said yesterday.
And you referenced that we're in a higher interest rate environment, but it is a decreasing interest rate environment right now. Would you agree with that?
I wouldn't. I mean, it's been floating around 4.5% and 5% for the last 18 months or so. The Fed cut rates last week and the interest rates went up. Usually that doesn't happen. But the last several times, so the 4 times they dropped it last year and the last 2 times they dropped it this year, the interest rates are kind of acting wacky like that. So I wouldn't say it's decreasing, and if anything, it would be more flat than decreasing. I don't know what's going to happen. If I did, I wouldn't be here. But I would say that if you're looking at the projected interest rates from Blue Chip and things like that, and me and Mr. Gorman used them in the cases, you can see that it's still sticking above that 4.5 to 5 range, and that's going forward through like 2032. So I wouldn't agree that it's a decreasing environment. I don't know what's going to end up happening, but I don't think it's going to go back to the conditions that they were back in 2021, where you're at 2% or 1.5%. I don't think that's going to happen again. Well, not anytime soon, anyway.
can't say that I disagree with you there. That was a unique circumstance that most people I wouldn't think would envision again. But I think if the ROE goes up, or if it goes up too much, then the commissioners would have some explaining to do in terms of why. And I'm not sure I've heard that reason yet. You know, they have monopoly territories, and you know, the utilities it's a booming business right now. They can't build enough generation, I don't think. And it seems like, you know, even under the stipulation, even under the agreement, it would go up 0.5%, but at the same time, it seems like their risk is going down because of the ban. And what would you have to comment on that? You know, an increasing ROE in the face of decreasing risk.
Well, I'll start with the band, and then I'll work backwards, and if I miss something, just let me know. So as far as the band's concerned, again, we said that it's a temporary decoupling. It's a temporary decoupling mechanism. It's like a rate stabilization mechanism. I don't know if you're familiar with those, but as shown on DWD 12 in my direct testimony, those are prevalent within our proxy group companies. So if there's any type of risk-reducing factors for the decoupling mechanisms, they're already subsumed in the prices and the market data that we're using to do all those models. And I think I'm going to skip the middle piece, but I'll stay. So you were talking about, you know, the companies are monopolies and all this stuff. All of the companies that we're comparing LG&E and KU to are also monopolies. So when we're looking at the risk, looking at the market models as applied to those monopolies, the ROE, the required rate of return for those companies, in my view, is higher than 9.90. So generally, I would say that the 9.9 is a conservative piece. And then when we're talking about, you know, it's going up 0.5% from 9.4 to 9.9, I also think that's a small move compared to the significant increase in the base interest rates that were prevalent during the time of the last order. Okay, and then I think there was, and then you were talking about they have so much demand that they can't build enough generation. Well, all of the CapEx, all of that expenditures to serve the customers, all of that requires the companies to go to market. So they have to go to the market and they got to say, hey, we need X amount of millions of dollars or billions of dollars. And they have to say, well, how does your cash flow look compared to what's your free cash flow look like? And you're like, well, I got to spend a couple $1 billion on this, so I really don't know how much I can pay you right now. And I think that might be, and I think Ms. Borjos might be able to help you better with that, raising capital for you know, debt pieces, but all of that comes with risk. So when you're spending money to get to serve your customers, it squeezes all of your metrics, and now you have littler and littler margin for error. If something goes wrong, if you have bad weather, all of a sudden now you're getting downgrades. And then it takes a lot more to get back up to where you were than what it took you to go down. So it's not really it's a losing proposition when you're building all of those assets, and that's why the settling parties were like, all right, well, let's give you a rider, let's give you the sharing mechanism so that so you could effectively do your duties to your customers while, you know, making sure that everything's safe and reliable.
Yeah, there's some companies that we regulate that do have trouble meeting their allowed ROE.
Yeah.
But these companies don't seem to fall under that shadow. They seem to do very well financially year after year. And I would talk to you all afternoon, but I think I'll cut it off right now. Let the other commissioners ask questions.
Commissioner? I don't have questions. Any redirect?
Just have one question. Mr. Diascendis, staff council was asking you about the use of the same ROE for base rates and riders. Based on your experience in testifying before other state commissions, is it common or uncommon for there to be the same ROE for a base rate as the riders?
Generally, the ROEs authorized by utility commissions around the country, with the exception of Kentucky, have the same ROE for the riders and the base rates. There's one exception, which is in Pennsylvania, where the staff of the utility commission calculates it's the DISC, which is an equivalent of an infrastructure rider in Pennsylvania. They calculate it, but they don't say, all right, well, XYZ PPL utility in PA, you have an ROE of 10, and we're going to drop you to 9.9. It's set by the commission staff, and it's not a part of any rate case. So that's the only one that's weird, because you don't know if it's going to be higher or lower than what was authorized by the commission. But Kentucky generally is the only one, to my knowledge, that has, this is for base rates, this is for any type of mechanisms that you have.
Thank you.
Your Honor, I do have a couple questions. They are not necessarily directly within the scope of council's questions, but they are in response to Commissioner Wood's questions. And I just don't know if that's appropriate on redirect.
Is there objection to beyond the scope of redirect?
Not at this time, subject to hearing more about the questions.
Yeah, Mr. Diascendis, you said something in response to Commissioner Wood's question. I just wanted to make sure I understood. I think he asked you a question about the monopoly, and you indicated that all of the proxy group companies were monopolies. Is that correct?
Generally, yes.
But am I correct that by proxy group, you mean those that are on table 2 of your rebuttal testimony?
Yes.
So none of those are monopoly utilities. Those are all the publicly traded entities. Isn't that correct?
They're holding monopoly companies, yes.
Okay, and so just as an example, with respect to some of these particular entities, I'm going to use American Electric Power Company and First Energy.
Sure.
Some of the actual monopolies that are part of those holding companies operate in distribution-only jurisdictions like Ohio.
That's right.
And some of them, like Virginia, AEP has APCO that operates in Virginia that has some limited customer shopping.
I'll take your word for it.
So you're not familiar with Virginia Code 56577 that permits certain customers to pursue limited retail choice in Virginia?
No.
Okay. And so you would agree with me that all things being equal, that utilities, monopoly utilities that face retail choice deal with a different set of risks than a fully vertically integrated monopoly utility that has no opportunity for retail choice?
Yes.
And then I think I also wanted to clarify one other thing that you said in response to Staff Witness West, because I thought I misunderstood. You and he were having a discussion about the role of PPL and how it's important when the commission sets the ROE that it focuses not on the potential risk-reducing nature of PPL, but focuses instead on the specific risks of KU and LG&E. You recall that discussion?
Yes.
So help me understand why, if it's important for the commission to focus solely on KU, LG&E, that you are then asking the commission to take into account issuance costs that could only ever be incurred by PPL as the parent.
Yeah, sure. So PPL, when you issue equity, that obviously flows down to the subsidiary companies, the operating companies. Their responsibility is to pay that through dividends up. So when you're financing the equity of the operating subsidiary, those rates need to reflect the flotation costs so that the parent company is made whole for their issuances.
But if instead of issuing actual equities in the market, if instead KU LG&E were just to retain its earnings and not flow those back up to the parent company, there's no issuance costs associated with that.
There wouldn't be, but there may not be enough to make capital improvements and things like that, and that's when you have to look out to the parent for the capital.
And just one other question on the issuance costs. Did you conduct a specific review of PPL's issuances when you calculated the issuance costs, or was that just a generic calculation?
It was PPL's issuance costs.
And did you flow through those issuances to determine how much equity was actually pushed down
No.
to the company?
No, because dollars aren't, you can't figure out which dollar you're spending. Oh, this is a debt dollar, this is an equity dollar. You can't, once it goes into the balance sheet, there are dollars available to spend or invest.
Okay. And so you don't know, for instance, whether any of the recent issuances or the issuance costs that you calculated actually resulted in equity-based issuances, or those amounts of money that were procured as a result of an equity issuance being made available to KU LG&E?
Theoretically, it would have to be.
Why couldn't it have been a debt that did that?
Again, usually when you're looking at the capital structure, and Ms. Borgos might be able to answer some of these, but generally when you have the money in the pool for investment or pushing down, it's already mixed in. Once you get the money, it's in the balance sheet. It's done.
And are you telling me, do you know how common it is for a commission to authorize a company to increase its ROE due to publicly incurred issuance costs?
How common it is?
Correct. How often does a commission approve an increase in ROE as a result of these issuance costs that you've identified?
Generally, Florida has issuance costs, Minnesota has issuance costs, and for flotation costs. Generally, every single debt issuance has issuance costs that are flowed through to the embedded debt cost rate.
Okay, so you're aware of 2 jurisdictions that have done.
Well, I'm just 2 that come off the top of my head, yes.
So for the other 48 jurisdictions, when they're setting the market cost of equity and investors' required expectations for ROE, clearly then the majority of investors are assuming that the ROE that they're being awarded is going to already account for any embedded issuance costs.
Investors would know that none of the ROE models reflect issuance costs or transaction costs, so that has to be reflected in other ways, and the issuance costs or the flotation costs is the easiest way to do so.
Thank you, Mr. Diascendis.
Yeah.
Any further recalls? Any reason this witness couldn't be excused? Thank you.
Thank you.
Next witness.
Company's next witness, Your Honor, is Mr. Chris Garrett. And Ms. Wimberly will present him, Mr. Garrett.
Mr. Garrett, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat.
Thank
Tell us your full name and business address.
Sure. Christopher M. Garrett, 2701 East Point Parkway, Louisville, Kentucky.
Good afternoon, Mr. Garrett.
Good afternoon.
Would you please state your employer and your job title for the record?
Sure. I'm employed by PPL Services Corporation, and I am the Vice President of Financial Strategy and Chief Risk Officer.
Did you cause to be filed in the record of these proceedings direct testimony, rebuttal testimony, joint stipulation testimony, and joint supplemental testimony?
Yes.
Did you also sponsor responses to certain data requests in these proceedings?
Yes, I did.
Do you have any corrections to that testimony or those responses?
I do not.
The witness is available for cross, Your Honor.
Okay. Attorney General,
AG has no questions.
KIUC,
No questions, Your Honor.
Sierra Club.
Good afternoon, Mr. Garrett.
Good afternoon.
I'm Nathaniel Shope on behalf of Sierra Club. I have some questions for you about the testimony you filed on Halloween, the Mill Creek 2 adjustment clause and the Incident 5, which was the preliminary bill analysis for Mill Creek 2 adjustment clause. those topics that you can address today?
Yes,
Okay. So my understanding of this Mill Creek 2 adjustment clause is that there are costs associated with extending the life of Mill Creek 2 beyond its previously approved shutdown date. Is that right?
that is correct, the stay open cost.
And that, that prior retirement date was in 2027 when Mill Creek 5 comes online. Is that accurate?
Yes, that is correct.
Okay. You just used a phrase that I'd like you to tell us what it is and what it means. Stay open costs. What are those?
I would defer to Mr. Beller. He can probably give you a better answer than me. But obviously, those would represent incremental cost associated with extending the life of Mill Creek 2.
Okay. Let's look at your rebuttal testimony on page 5, line 17. This is regarding the preliminary bill analyses that were submitted on Friday evening. You write on line 17, the preliminary bill analyses are based on reasonable assumptions and modeling available at this time. Did I read that accurately?
Can you repeat the reference?
Oh, yes, it's page 5 of your testimony on line 17. Sorry, this is the Halloween testimony that was filed on Friday night. I believe it's titled Joint Supplemental Testimony. Do you see that reference?
I do.
Okay. To your understanding, what are those reasonable assumptions that went into the bill analysis?
Again, I would defer to Mr. Beller with regards to the Mill Creek 2 stay open.
Okay? Same question, but with regard to the modeling. Is that also Mr. Beller?
Well, certainly, I think when we speak to this, this is really focused on the business plan and what's included in the business plan around what the stay open costs associated with Mill Creek 2.
Okay. The bill impact analysis that was submitted as Exhibit 5 to your testimony on Friday evening was an Excel spreadsheet.
That is correct.
Is that the modeling that is available that you're referencing?
No, there would be
Page 5
another
of your
layer,
testimony.
right? We would be looking at our O&M, a breakdown of our O&M costs as well as our capital costs, which certainly Mr. Beller will have a better understanding of the specifics with regards to those costs.
Okay, I just want to make sure I understand what your testimony means. When you write on page 5 of your testimony that the bill analyses are based on reasonable assumptions and modeling available, that available modeling is not Exhibit 5 that was submitted on Friday night, but is actually operations and maintenance costs and capital costs and potentially other things.
Well, let's talk a little bit about what all is included. Certainly, and maybe this is where it might be a little bit confusing in my response. First, there are costs, right? What we're saying there, right, is what I'm trying to relay to you there is the associated costs that are included in the modeling. Those are better addressed by Mr. Beller, right? Now, with regards to the mechanics of the mechanism, certainly Mr. Conroy and I can answer those questions with regards to how the cost, if you will, feed in and are collected, right? And we'll run through this rider, right? How they're collected from Group 1 and Group 2, that's all reflected as well as the estimated bill impact on the schedules.
Okay, so you can talk to us about the mechanism, but not what's in that mechanism?
That is correct. Mr. Beller would be best to explain the exact type of costs that are included.
Okay, so if I want to know, for example, if these stay open costs include maintenance, that's a question for Mr. Beller?
Yes.
And if I want to know if they include major projects such as an SCR, that's a question for Mr. Beller?
That is correct. He would have the specifics on the various costs that would be included.
Okay, let's turn to page 13 of your testimony. On lines 19 to 22, do you have that up in front of you?
I do.
All right. You see on line 19 where it says this bill analysis is based on, quote, reasonable assumptions sorry, let's move down just a bit. Line 19, you say this attachment, the company's endeavor to provide the commission with a quote, general illustration of potential bill impacts under this proposed mechanism. However, the bill impact is subject to change as actual bill impacts will depend on a variety of factors. Read that accurately?
That's correct.
What are those factors?
Well, obviously, the extent of the cost, right? Whatever costs are actually incurred. Obviously, these include revenue assumptions, right? Because we are basing this on Group 1 and Group 2 methodology, which includes various revenue assumptions. And as over time, right, those revenues will be different than what is included in the analysis. So I would say that those are the two primary changes that will occur that I'm aware of at this point in time.
Okay. Let's look slightly further down. On line 23, you write, the analysis should be viewed as illustrative and not predictive of final outcomes. Did I read that correct?
That is correct. Again, the actual cost, that is the one important thing with all these mechanisms, right? It will only recover the actual costs that are incurred.
Okay, so how much should customers expect those costs to deviate from the numbers that are in Exhibit 5?
Again, I would say to that, Mr. Beller would be best, but we are going to spend what we need to spend to keep the unit operating safely and efficiently.
I understand I should ask Mr. Feller, but any chance you have a ballpark figure? Are they 30% different, 50% different, 80% different?
I don't have a ballpark figure. I would just say that, you know, these units are significant, right? It's a large coal-fired unit, right? Subject to a lot of components and moving parts, and so there is variability with that.
Okay, let's back up one page, page 12, if you will, sir. Your testimony, at lines 20 and 21, you write, neither LG&E's current rates nor the rates proposed in this rate case includes the stay-open costs associated with extending Mill Creek 2's life. Have I read that correctly?
Yes.
Okay. Were customers notified in any of the public meetings associated with this case that the company is seeking approval of these Mill Creek 2 cost recovery mechanisms?
I do not know the answer to that question.
How does the company intend to alert customers to the fact that it might want to keep Mill Creek 2 open longer than planned? That decision will be made at some unspecified point in the future, and that the company wants to recover costs right now associated with that future decision.
Can you repeat that question again?
How does the company intend to tell customers about this plan?
Mr. Beller would be best to answer that question. I would certainly say, though, that the order that was issued last week in the CPCN proceeding certainly acknowledges that Mill Creek the life will extend.
My question was about how the company intends to let its customers know about its plans with regard to Mill Creek 2, not about the commission's order.
Yeah, Mr. Beller would be best to answer that question.
Okay. Do you know if the company has already notified customers at all of its plan to keep Mill Creek 2 open longer than its approved retirement date?
I'm not aware of those specific communications. Mr. Beller could probably answer that.
Okay. Let's move on to a different part of your testimony on page 14. This is lines 19 and 20. You write the benefits are about $3 million per year on average from 2028 through 2030, and they are not included in the preliminary bill analysis. I read that accurately.
That is correct, yes. That represents in essence, the fuel savings that will flow through the FAC.
And are those $3 million annual in asserted benefits supported somewhere in this record?
I'm not aware if that is supported in the record.
Sorry, could you restate up?
No, I'm not aware. Mr. Beller could probably answer that. that's probably likely a value that was determined in the CPCN proceeding. But he could tell you.
But they weren't in the testimony that was filed on Friday, correct? There's nothing in the testimony that you filed on Friday, in your testimony, that supports this $3 million figure, is there?
No,
Is there something in the exhibits, specifically Exhibit 5, that supports this figure?
it does not.
Any in the direct testimony that was filed in May of this year?
Not in my direct testimony, no.
In the rebuttal testimony that was filed in September of this year?
Not to my knowledge. Again, Mr. Beller could probably answer better.
Okay. Or at the technical conference in August?
Not as it relates to Mill Creek 2. I don't believe any of this has been addressed in this
Okay.
proceeding.
So if it's not in this record, any of those places, what backs up that $3 million figure?
The production cost modeling included in the CPCN proceeding is likely the support for that figure.
I'm just making a note of this answer.
Again, I would defer to Mr. Beller with specifics with regards to the CPCN.
Okay, let's turn to page 15 of your testimony from this Friday. At lines 10 and 11, you write, at the time LG&E filed its rate case in May 2025, it did not plan to continue to operate Mill Creek 2. When did that change?
That changed as a result of the CPCN proceeding, 25045.
And what was the date of that change?
Obviously, the order came out associated with the CPCN last week with regards to Mill Creek 2.
I understand when the commission's order came out. I'm asking when the company changed its mind about the retirement date for Mill Creek 2.
Mr. Beller would be best to answer, but obviously I think that was part of the stipulation that was reached in that proceeding. So I would say that's when the companies determined that they would keep Mill Creek 2 open.
Okay, so that stipulation was July of 2025, is that right?
I'm not sure when that was.
Okay. On page 15, line 13, you write LG&E has incurred and will continue to incur Mill Creek 2 stay open costs. Have I read that correctly?
Could you repeat the line item?
Oh, page 15, line 13 of your testimony. LG&E has incurred and will continue to incur Mill Creek 2 stay open costs. Have I read your line correctly?
Yes.
Okay. When did the company start to incur stay open costs?
They have begun incurring costs, I think, as early as July 2025. Mr. Beller could certainly provide more specifics, but those costs have begun in 2025. And in fact, the unit was just in an outage, and those costs were incurred. I think it just came off the outage.
What kind of costs are incurred repairing or making it come off of an outage?
I don't know the answer to that. That's certainly more Mr. Beller's expertise.
I will ask him that. Thank you. All right, so you think it might be July of 2025 when the company started to incur stay open costs?
Can you pull up the workbook that we put together, the spreadsheet? Yeah, it looks like I'm showing that effective July of 25.
Okay. So before the August 19th technical conference in this case?
Correct.
And before the rebuttal testimony in this case?
Yes.
Got it. All right. How much are those stay open costs today?
Can you repeat that? How much are they?
You have said
the company has incurred stay open costs beginning in July of 2025. I'm wondering what the stay open costs to date are. What's the number associated?
Well, according to the model, right, and Mr. Beller certainly could provide additional details on this. There's approximately 329,000 of capital, and then there's $605,000 of O&M.
And that's 605,000 of O&M. That's O&M that would not have been incurred if the company didn't intend to keep Mill Creek 2 open beyond 2027?
I would defer to Mr. Beller with regard to the specifics of that O&M and what that represents and whether or not it would have been incurred. He's best to answer the specifics on that.
Okay, just a couple more questions. If this Mill Creek 2 adjustment clause is approved in this docket, when do customers start getting billed?
Well, obviously, it would depend on when the order, but I would think no sooner than 2026, no earlier than 2026.
What's the earliest conceivable time that you think it would happen? Would it be January? Are we talking February, March, some other time?
I would.
Objection, this has already been asked and answered. He said it depends on when the commission's order is issued, Your Honor. That's what he said. Now he's asking Mr. Garrett to guess as to when the commission's order is going to get issued. The commission is in charge of when it issues its order in this case.
So you can answer if you know, and if you don't know.
I don't know the answer, but let's just assume that the order is approved at the end of the year, right? Obviously, I think the first time that you would have a bill take effect would be February. But again, that is just based on my understanding of how this would work. So it will depend on exactly when the commission not only issues the order, but would approve the forms as well. So it's kind of outside of our control a little bit.
Mr. Garrett, I appreciate that answer. I know you're not in control of all of the information here, or all the processes here. Would you turn to page 3 of your testimony and read the final sentence that begins at the bottom of page 3 and continues on to page 4?
You want me to read which?
I would like you to read the final sentence of page 3 that continues on to page 4 for us, sir. It's your testimony.
In filing this supplemental testimony, the companies provide additional information to ensure they meet the substantial evidence standard.
All right. I would like you to read that next sentence, that last one on page 3, line 21.
Sure. The companies also welcome questions at the hearing to ensure the commission and all parties have the information needed to thoroughly evaluate the proposed mechanisms.
That is the point of my questions, sir. I'm trying to elicit an understanding of the testimony that you filed on Friday afternoon. So the reason I'm asking you about when customers might see these bills show up is because the only place I have to look for that information is in your testimony. You understand that?
I understand your question, yes.
Okay. So if this gets approved by the commission, let's say at the end of the year, under your potential timeline, which I'm not holding you to, but it gets approved at the end of the year, it's submitted in January, and they show up on customers' bills in February. Is that a potential timeline that we're looking at here?
Potentially, yes.
Okay. Let's say that all of those things happen, and then later, at some point in the future, companies decide that they want to stay with the currently approved shutdown date for Mill Creek 2, which is in 2027. The question is, if those things come to pass, do customers get reimbursed for all of these stay-open costs for a plant that is not going to stay open?
I think Mr. Conroy clearly explained that this mechanism is subject to review on both the front end and the back end, right? So there is due process for review by the commission with regards to what costs are included before it takes effect on the bill. And then, of course, annually, it would be part of another review.
I understand there's a review process for the commission. My question is, if the company seeks and gets approval for stay open costs, and then the plant doesn't stay open, do those costs get returned to customers?
I think it would depend on the facts and circumstances of why that decision was made not to keep it open, right? If, as we sit here today, right, we believe the cost should be incurred because we believe it will stay open beyond 2027. If that somehow changes in the fact, then certainly that would be up to the commission to decide what should be done with any of those costs that were incurred.
Okay, Mr. Garrett, I don't have any other questions for you. Thank you for your time.
Thank you.
Mr. Spanos?
Yes, we have a few questions. Good afternoon, Ms. Garrett,
Good afternoon.
and you can hear me, right?
I can.
I called you Spanos. It's
That's okay.
Nard, I'm sorry.
It's quite all right.
There was no confidence.
If you don't understand a question, you're going to let me know, aren't you, Mr. Garrett?
Yes, I will.
Thank you. And in terms of your title, Vice President, Financial Strategy, and Chief Risk Officer, did I say that accurately?
You did.
Okay, and with regard to the word risk, what does that comprise? What risk are you chief officer over?
So I oversee the enterprise risk management for PPL and all of its subsidiaries.
Okay, so it's over PPL and all the subsidiary, all the members of the family, correct?
That is correct.
And then is it, for example, information technology risk? Is that one of the risks you oversee?
That would be one of the risks. Again, there are obviously business owners to each of those risks that are across the enterprise, but my role is making sure that I identify and basically review those key risks and make sure that they're being properly addressed
For the PPL family?
for the PPL family.
Okay. In terms of your business address, it's 2701 East Point Parkway, Louisville, Kentucky, is that right?
That is correct.
Okay, and that his testimony speaks for itself, but that's also the business address of Mr. Conroy, is that correct?
Yes, it is.
Okay, but the difference is that, well, let me ask the question this way. Mr. Conroy's testimony is he's Vice President of State Regulation and Rates for Kentucky Utilities Company, KU, and Louisville Gas and Electric Company, LG&E, and an employee of LG&E and KU Services Company. Is that your understanding of his who has him as an employee?
That is correct.
Okay, and you, on the other hand, you're employed by PPL Services Corporation, is that correct?
I am. I do hold a couple of different roles, so it might be helpful to mention that. As it relates to the utilities, LG and KU, I'm also the VP of Finance and Accounting as it stands today.
Thank you, I appreciate that. With regard to your testimony, first page of your testimony, and this is the testimony that was filed in support of the application, May 30th, 2025. Do you have that in front of you?
I do.
Okay. I'm looking at page 1, and this is the discussion that begins line 19, service company allocations. And I'm not going to try to pronounce that one name. I'm just going to refer to it as Rhode Island Energy. Do you see that discussion on lines 22 and 23?
I do. It's Narragansett Electric Company.
Okay, thank you. And on line 23, beginning on line 23, the consummation of this transaction creates additional scale and scope to PPL's operations. Do you see that?
I do.
Okay. What do you mean by additional scale and scope to PPL's operations?
obviously, that brings another domestic utility under the ownership of PPL Corporation. So, as Mr. DeSantis mentioned a while ago, right, there are operating businesses, if you will, in not only Kentucky with LG&E and KU, but there's PPL Electric Utilities in Pennsylvania and Rhode Island Energy in Rhode Island. So utilities in 3 different states.
Okay, turn to page 2, please.
Okay?
And this is on line 1. It talks in terms of the words, PPL took the opportunity to look across the PPL family of companies to share best practices, considered a more consolidated shared services approach, and improve operational efficiency to reduce costs for the retail customers of its utility operations. Do you see that?
I do.
Okay, so is it your testimony that, in your opinion, it is a benefit to KU and LG&E to be part of PPL rather than simply standalone entities?
Yes, I do believe that, right? There is a benefit for being part of a larger group and we've indicated it on an annual basis. Those benefits include the sharing of best practices across the operations on many, many different fronts.
And some of the examples of those fronts listed on lines 7 through 12 of page 2 of your testimony?
That would certainly be on the side of the shared services functions, right? The centralization of the shared services functions. But there are also benefits on the operation side as well that are shared across the enterprise.
Okay. With regard to the testimony on page 2, lines 13 to 16, the question is, does that mean that all of the services are now being performed in Pennsylvania? And the answer is no. Many Kentucky-based employees are now employed by PPL Services. Work performed in Kentucky is also assigned to other PPL affiliates. Do you see that?
Yes.
Okay. So with regard to the notion of the PPL affiliates, are there PPL affiliates located outside of Kentucky that are performing work on behalf of Kentucky?
Yes, I mean, there are employees in Pennsylvania that are performing services for Kentucky, and as well as there are Kentucky-based employees performing services for Pennsylvania.
Okay. A moment, please. I need to look at a note. Thank you, Mr. Garrett. No further questions.
Okay. Joint interveners.
Yes, thank you, Your Honor. Good afternoon, Mr. Garrett.
Good afternoon.
How are you doing today?
Good.
Good. So I wanted to go back to Exhibit MC5 to your supplemental testimony. Exhibit 5 to the supplemental testimony about the MC2 estimated cost recovery.
Yes.
Okay. And I'm going to do my best to not cover anything Mr. Schoaf already covered with you, but I do have some questions on the MC2 LGE tab. Not about the specific costs that go into that. I understand that's questions for Mr. Beller, but wondering kind of how this works, how this analysis works that you've done here. And are you the one that put together this tab?
It was an analyst on Mr. Conroy's team.
Okay. Are you aware of kind of the general approach taken in this?
I am.
Okay. And just to be clear, the line 16 provides a jurisdictional MC2 revenue requirement, is that right?
That is correct.
Okay, and that is the revenue, the requirement that is used to calculate the jurisdictional amounts that are identified on the estimated bill impact tab?
Yes.
Okay. And so I understand here, the revenue requirement is essentially the return on rate base plus O&M, depreciation, and property tax?
That is correct. It includes both capital and O&M.
Okay. Okay, and the capital flows through the return on rate base?
It does, as well as you'll see the depreciation being a component of the operating expense. So it's a typical revenue requirement type model for utilities.
Okay, great. And then looking up at line 3, plant and service, what does that reflect for MC2?
That would represent capital spend that has been unitized and placed in service. So for example, if you, when you spend the funds, typically it may stay in CWIP until that becomes what's known as in service, meaning it becomes operational. And so once it becomes operational and in use, then it moves from CWIP into plant and service.
Okay. If the companies make $1 million in capital investment in Mill Creek 2, as it's being made, the investment's being made, it would first appear in CWIP, line 4?
That is correct. I mean, there are times when it could go straight to plant service, but typically, for the most part, it would run through CWIP first before being placed in service.
Okay. And then as soon as it goes into service, it appears up on the plant and service line?
That's correct.
Okay, and so like if you look at, you have costs under CWIP for July through November of 2025. They go from $329,000 to $2.516 million.
Correct.
Okay, and then the CWIP number becomes negative in December 2025, and the plant and service value in December 2025 jumps to $3 million approximately, correct?
That's correct.
Okay, so that would be some sort of an investment. I am not asking this specific investment, but that would be some sort of investment made in Mill Creek 2 in the second half of 2025 that then will go into the plant and service value at the end of the year.
Yes.
Okay. And then to calculate the rate base, you take that plant and service, the CWIP, and then you subtract out accumulated depreciation. Is that right?
You do, yes.
Okay.
That's deferred taxes and add in working capital.
Okay. And then the accumulated depreciation is the total of, the cumulative total as you go of line 12? Depreciation?
Yes.
Okay. And how is the depreciation values here calculated?
It would be based on the plant and service times the applicable depreciation rates for Mill Creek 2.
For the plant itself or for each investment in the plant?
It would be based on the plant account for Mill Creek 2. So Mill Creek 2 will have various plant accounts, and so there are rates in our depreciation tables that were filed as part of the stipulation. Those rates are in essence by every plant account. So there's a Mill Creek 2 structures, for example. There's a Mill Creek 2 boiler plant on down the line.
Okay. And I guess just trying to figure out, given that my understanding is this exhibit only reflects stay open costs, correct? It's not the baseline operating cost for the plant, it's the stay open cost?
It represents the stay open cost, but when you look at O&M, right, that would be a comparison of the total O&M versus the baseline, so it would represent the difference.
Okay. And when you're looking at depreciation?
That should be only on the incremental capital here, so that should not be compared to a baseline.
Okay. And the incremental capital is what we were talking about in lines 3 and 4?
Yes.
Okay. Okay. And so the accumulated depreciation in your estimate of bill impact, it resets every month, correct?
Repeat that question again?
The accumulated depreciation is recalculated every month in this mechanism?
That is correct, right? It would reflect the current month's depreciation. And we may use it, with regard to the spreadsheet, we may be using a blended rate for all in for Mill Creek too. I'm not sure. I would have to I would have to check on that.
I'm sorry, what is an all-in blended rate?
So, for example, you could take all the different plant account rates and come up to a blended rate and apply that to the additions here. I'm not exactly sure how we've done it here, and whether or not we've done it by component. My guess is we've used a blended rate and simplified the calculation.
To calculate what?
Depreciation expense.
Okay, and that would be the same rate that would be used in the actual mechanism determination of bills if this were approved?
It would be. Again, it's a blended rate representing all the different rates combined, right?
Okay. Now, the plant and service value, it appears to me, it seems to jump significantly in December of each year. It goes, November to December of 2026, it goes from 3.3 million to 7.5 million. And then in November to December, it goes from 7.5 million to 32.4 million. Mm-hmm. So is the plant and service in this calculation only being reset every year as opposed to every month?
I do not know the answer to that, but certainly it would appear that this could be using a simplifying assumption. We could answer that in a post-hearing data request to determine whether or not we've just unitized everything at the end of the year.
Okay, to your knowledge, if this mechanism were approved, would the actual plant and service value that goes into this, the surcharge calculation, be reset every month or every year?
It will be whatever is recorded for accounting purposes. Again, these will be the actual cost. This is just a projection as we sit here today. We've used our best judgment, probably taken information from our business plan. But what will run through the mechanism will be the actual cost per the books.
Okay, thank you. I guess I'm trying to figure out, if there's an investment in, cost incurred, capital cost in June of a particular year, is that going to show up or proposed to be showed up in the?
If it's placed in service in June, it would be reflected here in plant and service in June.
In June, okay. So it would not be it wouldn't wait till the end of the year?
No.
Okay. Okay.
But there may be a very good reason for that, why it's every December. I'm just not sure.
Okay. Okay. And then the property tax, that is just the incremental amount? That's not the whole property tax of the plant as a whole, correct?
Correct. That's it. That's the incremental.
Incremental amount, okay. And that also appears to reset every year?
Yes.
Okay.
The utilities are centrally assessed, and the valuation's always as of the end of the year. And so that property tax value is set, and then that's reflected for the 12 months following.
Okay, and in the actual operation of the mechanism, in calculating the surcharge, that would reset monthly or every year?
That would reset every year.
Okay, all right. Okay. Thank you, that was very helpful I'm not an expert on on how these things work, so it's very helpful to know. I do want to, I believe earlier, Mr. Schoaf had asked you what stay open costs had been incurred so far. And I believe, correct me if I'm wrong, you gave the number of $329,000 in capital and $605,000 in O&M.
That is what the spreadsheet details in July of 2025.
Okay, but that's only for July, right?
That was what I quoted here. It was just the first month and when we began.
Okay, but if we're looking for what has been incurred so far to date it would be all of July through October in this chart?
I would say likely, these may include estimates, right? We would not close our October books until a few days from now, and so I'm not sure exactly what's actual versus what's the forecast.
Okay. Do you know who would know that?
We could certainly follow up with a post-hearing data request to determine that.
Okay. And then one other question, I see that the, on line 9, the allowed monthly rate of return doesn't start till January of 2026. Would there be no return on the capital investments for 2025?
That is how we have modeled it, right? We know that, we have based this on the fact that we would not be able to earn a return on the capital spend until it is approved by the commission.
Okay.
Thus, we would forego any return on capital spent in 2025.
So when you seek to collect those, if the mechanism is approved, when you seek to collect those amounts through the mechanism next year, it would not include any return?
Exactly, that we would recover no carrying costs associated with those capital investments until approved by the commission. Now, the O&M, what we have modeled here is that we have reflected the O&M, and we would plan to recover that in the first month that it takes effect. So all the expenses that are determined prudent that were incurred in 2025, once those are approved, right, when the mechanism is approved, we would plan to include those in the first expense month.
And that would be all the O&M expenses. And then, oh, okay. Okay, that would be all of the O&M expenses,
Didn't die.
all the actual capital expenses, but no return on the capital.
That is correct. We would recover the O&M, and then, but we would not start recovering any of the capital costs until for example, in the model here, it would be January of '26. But again, it would be subject to the commission's approval, right, and review.
Okay. Okay. Okay, and then on the O&M costs that are line 11, there's a few months, usually October, in which it's negative. Do you happen to know why?
Mr. Beller probably could answer it better than I can, but I do know enough to indicate that what we are doing is we are comparing to the amount that is included in the current proceeding, right? So the 2026 test year, there is a level of O&M for every month that is in the test year.
Okay.
We are comparing now the total cost of keeping Mill Creek 2 open to that baseline level that is included in this proceeding, to ensure that there's no double recovery of cost.
Okay.
That's why it goes negative, because obviously there must be some O&M, and a large amount of O&M in October of 2026.
Okay, there's also negative October 2028 and 2029, which is beyond.
Again, that baseline will stay the same. You're always comparing to what's included in this test year.
Okay, okay, thank you. Now I understand. Okay, changing topics. Do you have the GCR work paper that was supplied by your council yesterday? It's supporting the.
Sure, the declining balance.
Yes, the declining balance, yes.
We'll pull it up.
I just realized I don't believe we've never actually marked this as an exhibit. So I will go ahead and mark it as an exhibit. Are we on two?
The foundation or anything? Or did we do that?
Are you, Mr. Garrett, are you aware of this document?
Yes, I am.
Okay, and did you have any involvement in creating it?
I was not involved in creating it. I did review it, though.
Okay, do you know who created it?
The source of this is information from our CPCN proceeding. It's our financial model that was used to determine the revenue requirements for the various investments.
So this is the rate case supplemental testimony work paper GCR collection benefits?
That is correct. Again, we used our financial model that was the subject of the CPCN proceeding to determine the revenue requirements. You'll see from the spreadsheet, right, there's percentages at the top. So if you look at kind of, you can see the capital cost in cell D7 through D11 for the various units. Do you see that?
Yes, yes.
All right. And then you see the various percentages, right? Those percentages are from the financial model. And Mr. Beller could probably speak to it better than I can with regard to what's included.
Okay. And then, so those percentages, happy to follow up with Mr. Beller. I'm just curious, do you know what those represent specifically?
Not specifically, other than they are the revenue profile, the revenue requirement profiles of those various investments.
Okay. Okay, and then so lines 14 through 20 and lines 25 through 31 have some projections around two different options. One called the perfect rate treatment, which I believe represents GCR, correct?
That's correct.
Okay, and then one represents recovering costs through periodic rate cases. Is that right?
Yes.
Okay, and what's the source of those numbers?
What's the source of those? Those would be from the financial model that's used by our generation planning team for the CPCN.
So those come from the CPCN process?
Well, they involve the use of the financial modeling, the financial model that's used to determine revenue requirements in that proceeding.
Okay, but the financial model that created these actual numbers in this exhibit, or in this work paper.
Again, it's a financial model that models revenue requirements, right, for various investments.
Yes, but that was run not as part of the CPCN, for this?
It was run, correct, it was run for this.
Okay, and do you know who did that?
I do, it was our generation planning team.
And is anybody from that team?
Mr. Beller would be best to answer questions with regards to that question.
Okay.
If not, Mr. Schramm.
Okay. And let me know if I should ask someone else, but I want to make sure I cover it with you if that's appropriate. Basically, the question I had asked Mr. Conway earlier, I'm looking at, for example, Mill Creek 5, line 15, for the GCR scenario. It identifies a cost per year, correct?
Correct.
And what do you know what that cost represents, like the 112 figure for 2027?
It would be the total revenue requirement for the initial capital investment for Mill Creek 5.
Okay. And that is the revenue requirement that in this scenario would be proposed to flow through the GCR, correct?
That is correct. It would be a component, yes.
Okay. And in the next year, 2028, it declines to 111, and then in 2029, 108.
Sure.
Okay, and that decline is due to what?
That is the reduction in the carrying cost as a result of the declining balance. Right, so rate base is, once this unit, right, the GCR, the important feature of it is it doesn't take effect until the assets are placed in service. Right, so once the assets are placed in service, the initial investment will depreciate from that point forward, right? And so this reflects the rate of return times the annual depreciation, if you're looking at it on an annual basis, but in essence, it's every single month. The rate base will decline every single month.
And is this reflecting what we spoke of earlier, that in calculating the rate base, you subtract out the accumulated depreciation?
That is correct.
Okay. And so in doing this in the work paper, you're showing a decline for, 2028, 2029, and then in 2030, you have 105, so it continued reflecting the accumulated depreciation for Mill Creek 5, correct?
That is correct.
In the GCR scenario, right? Okay, and then looking at line 26, you have Mill Creek 5 in a scenario in which the costs are recovered through periodic rate cases, correct?
Yes, correct.
Okay, and the value for 2027, 28, 29 is 112 in each year because that accumulated depreciation is not deducted?
No, it is deducted, but again, when you think about a base rate case proceeding, right? For example, in this case, there's $11.3 billion in capitalization. The carrying cost associated with that $11.3 billion is fixed. So we're going to recover that same carrying cost until base rates are reset. So, right, so to the extent that you don't have additions, right, the rate base is going to decline. And the benefit of the GCR is that every single month, that carrying cost will decrease. Whereas if it's subject to base rates, that carrying cost stays fixed for those 3 years while your rates remain the same.
But then that carrying cost decreases in this work paper in 2030 when you have the new base rate set, correct?
Then it aligns again, right?
Okay. But why does it, given that you have paid, customers have paid more in 27, 28, 29 combined in the periodic rate case than in the GCR scenario, why is the 2030 value that it resets to the same in both scenarios?
Again, that's the carrying cost. That is the primary difference in the carrying cost on the depreciation. So the company, again, the carrying cost level that is set in base rates remains the same until base rates are reset.
But if the
depreciation continues, the value of the rate base continues, but the carrying costs are fixed, right? It's not perfect rate recovery. Again, if you think about it, just it's almost what I would call reverse regulatory lag, if you will.
Right.
Typically, as the company spends more money, right? So, for example, $11.3 billion in rate base and capitalization, as we sit here today. If we go out in the next 2 years and we spend $1 to $2 billion, right, in additional capital, right, our rate base is going to grow, but we earn no additional dollars, right? Our rates are based on the 11.3. If we didn't spend anything, right, it's still based on 11.3, the carrying cost that we're earning, but the value would decline. So that rate base or capitalization would decline over the 2 years if we spent no additional capital. Again, it's a carrying cost concept. You've kept it fixed. It doesn't change under base rates.
So the additional $5 million that customers pay in the periodic rate case scenario over 2027 through 2029 does nothing to reduce the carrying costs in 2030 compared to the GCR scenario.
That's correct. There is no true up of that carrying cost.
So where does that money go? Does it reduce rates elsewhere?
No, there's puts and takes in rates all over the place, right? Again, we're setting a rate case. We're setting rates today based on a forecasted test year for 2026, based on $11.3 billion, right? If we spent nothing, if we spent nothing the next 2.5 years while we're in this stay out, right, the value of that $11.3 billion would be something less. If we did nothing, that's not realistic, right? And so again, but we would have been recovering the carrying cost in 11.3 billion. And let's say it went down by 2 billion. So it went from 11.3 to 9.3.
Right.
Right? That carrying cost is not trued up, right? It would reset when we file the rate case in 2.5 years, then we would earn a carrying cost on 9.3 billion.
And in resetting it, it is not relevant. The fact that customers in the periodic rate case scenario have paid $5 million more than they would have in the GCR scenario doesn't lead it to reset it at lower value in the periodic rate case scenario.
I wouldn't say that, I don't know how I would phrase it that they paid more. Again, I would say they paid what was based on the base rates.
But I mean, the actual amounts they paid according to this work paper is they would pay $5 million more.
And incremental carrying cost.
And then does that extra $5 million of revenue for the company offset any customer costs elsewhere?
It serves to mitigate the carrying costs on the other end, right? It's what I said, it's reverse regulatory lag. So it serves to offset the incremental investment that's occurring elsewhere.
The incremental investment occurring elsewhere, like other spending by the company.
Absolutely.
So that extra $5 million here would offset something else that might otherwise lead to a rate increase.
That is correct.
Okay.
Yeah, I mean, that's normal rate making. That's a normal rate making concept.
Okay. And then both of these scenarios assume no additional capital investments in any of these units, correct?
We have modeled this just based solely on the incremental capital cost of the initial investment. So the initial investment is all that's included. So I said incremental, the initial investment.
Okay. So any incremental capital that was spent on any of these units included in the GCR, in reality, would add to the rate base and the plant and service value, correct?
Yes, it would.
Okay. And would that spending add to the plant and service and the rate base more quickly in the GCR scenario than in the periodic rate case scenario?
Yes.
Okay.
That would be the inverse of the situation that, with regard to the carrying costs. So there would be a value, there would be a benefit to the companies associated with being able to include additional investments as they are made. Again, though, customers will receive, once that investment's made, they will receive the benefit of that as well, the declining rate base balance benefit of that over time as well.
Okay. But the fact that the capital investments are in the GCR scenario are being added to the plant and service and rate base more quickly than they would in a periodic rate case scenario means that customers, there's an earlier added cost to customers from the incremental capital, correct?
To the extent there are additions, then yes, there would be an incremental adder to the bill.
Okay, and none of that is reflected in this work paper, correct?
To my knowledge, that's correct.
Okay, take a minute. Nothing further, Your Honor.
We are getting close to, we're right at 2 hours since we came in. We could take a break now, but let me see. Walmart, would Walmart have questions? I think she stepped out, okay. KBCA?
No, Your Honor.
No, okay. That wasn't creepy at all.
I was like, how did she do that?
Kroger, for the cities.
Madam Chair, we may, I would request a quick break to
Sure.
confer with Mr. Gardner.
That sounds fine. All right, we'll take 10. We are back on the record in cases 2025-000113 and 2025-00114. And let's see, we were down to figuring out if Ms. Cross had questions.
No question.
Okay. So then, staff.
Thank you, Your Honor. Mr. Garrett, I am going to try to catch all the questions that got passed to you from Mr. Conroy, is where I'd like to start, if that's okay.
Okay, thank you.
The first, I'll even try to go in the order, so if you are paying attention to that. The first question that Ms. Hatcher, I believe, asked that was passed to you was regarding the planned capital projects and how the lower revenue requirement might impact those planned capital projects.
In terms of the reduction in the stipulation, or what are you asking?
Well, the reduction in the stipulation from the requested increase, and then how much of an impact would that have in all your capital projects that you had in the application?
You know, I would say it should not have a significant impact. Obviously, right, there's no guarantees that the company will spend exactly as it had planned in the proceeding, right? The plan is only as good as the plan at the time it was created. There are changes that occur throughout the years, right, when new things come up. But we do not expect the lower stipulated increase to have an impact on our capital plans.
Do you think one of the reasons that might be so is because of the clauses or riders that are proposed in both the application and the stipulation, as well as the request for the deferred assets?
The deferrals?
Yeah.
Sorry. Certainly the two mechanisms, and that's what, you know, we've stressed as being so critical, right, to the stay out, right? The two mechanisms are, you know, hand in hand with the stay out provision, and that those do help accommodate that. We would continue to spend as planned.
Okay, the next category that I believe Ms. Hatcher had asked about was related to the ROE in the stipulation. Can you explain how the earned ROE as specified in the stipulation will be calculated?
With regard to the sharing mechanism?
Yes.
So we provided an exhibit, which was the mechanics of the sharing mechanism. And so that is exhibit number 3, and I would point you to form 1.10 reporting adjustment electric. And that will show you the mechanics. Now granted, we have zeroed out the amounts here, but obviously our earned rate of return will take a look at our, it'll be very similar to a base rate case proceeding, if you will. The schedule will walk you through the math. It's basically a mirror of Schedule A in the rate case proceeding. We've also included Schedule C, Schedule J, and Schedule H. Those are the typical revenue requirement schedules for determining a revenue requirement. And so we've modeled exactly the sharing mechanism after this base rate case and how that would work. Now, there are unique features, and I would start with the beginning, like line 1, capitalization, a 14-month average. Right? Typically, that is a 13-month average, but because the stay-out period represents 13 months, right, we have to add a 14-month average. And that is important because what we are saying is we're going to use an average, a 14-month average, which is agreed to by the parties with regard to the mechanics of that. Now, typically, when you think about earned rate of returns, or rate of returns in general, they typically represent 12 months of returns. That's a 12-month, it's an annual rate of return. Now, the sharing mechanism has 13 months, and so you'll see some formulas in here where it may take a rate of return, and for example, on line 3, and divide that by 13 and multiply it by 12. That's getting everything back to a 12-month rate of return. So we are going to compare what we earned from our actual results compared to what we should have earned, similar to this base rate case proceeding today, and compare those returns, and to the extent that the earnings are above 10.15%, if our earned rate of return is above 10.15%, we will return any excess to customers. Now, to the extent our earnings are below 9.4%, we will collect from customers any amounts below that level. And so the mechanics of that form are probably the easiest way to, if you will, if you want to play around with the numbers and see how that would work.
So just because you've mentioned several schedules and then the form and the calculation.
Sure.
And just to confirm, I think we heard Mr. Conroy say that the company intended for this to be a 30-day turnaround between the filing with the commission to review this information and the time the rates were going to be proposed to go into effect. Did we misunderstand that, or?
No, the filing timeline as proposed would indicate that we would file our report, if you will, our earnings report, on October 1st with new rates associated with the mechanism taking effect in November.
Okay. So, I think this is related somewhat to the ROE on that mechanism, but are you intending to have any regulatory liability or asset balance created as a result of the earned ROE falling outside of the deadband, either way, accrue interest at the WACC?
Repeat that one more time.
Okay. Are you intending that any regulatory liability or asset balance created from, I guess, each month, as a result of the earned ROE falling outside of the deadband, would that be accruing interest at the WACC during that 13-month period?
So let me try to unpack that a little bit and,
Okay.
and try to explain it in the way that I believe I understand your question to be. Obviously, with the reporting period, right, which is July 27 through July 28, we will not be collecting any of those revenues. So to the extent that we have an under collection or to the extent that we have an over collection, we will be recording a regulatory asset in the case of an under collection or a regulatory liability in the case of an over collection. We will not accrue interest on that balance. We will not gross that up for interest, if you will. Now, to the extent that that balance is included in rates, in a base rate case at some point in time where there's a balancing adjustment, possibly, but again, I don't think this will be subject to any type of interest.
Okay, that was where I was trying to go with that, but
Yeah.
thank you for filling in the blanks. The next question that was passed to you, I think, referred to the stipulation on page 13, section 6.1A. And just let me know when you're there.
Yes, I'm there.
Okay, and then that talks about property taxes for the first year shall be based on the construction work in progress. And Ms. Hatcher asked if, well, it wasn't entirely clear what first year meant. So could you explain a little bit about what first year means in the stipulation there?
That would mean the first year that it's in service, right? The first year that it takes effect inside the mechanism, and it's included in the mechanism. So to back up a little bit, property taxes are based on the end of year. I think I mentioned that earlier, right? We're centrally assessed by the state of Kentucky, and that is done as of the end of the preceding year. And so the property tax value is based on that year-end value, and that's no different than any other year, right? So The property taxes that we accrue and pay are based on a valuation as of the end of the prior year.
And that's why, is that, well, I mean, I'll just ask you to confirm. That's why in the Excel sheet, I think, on one of the tabs in the bill impact, the property tax goes up between that January, December period. I think in the GCR mechanism, maybe it did as well.
Yeah, subject to check, I would say it should reflect the additional additions taking effect.
Okay. So I think the next area, I'll just confirm, anything related to the Mill Creek Rider, Excel, related to the numbers and that type of thing, you'd like for us to ask Mr. Beller?
With regard to the specifics on the cost, yes, please.
Okay. And then, Ms. Hatcher also asked about the amount of well logging and inline inspection expense embedded in base rates. Mr. Conroy suggested that we check with you about the well logging and inline expenses typically embedded in base rates, or in this application, I guess, in base rates.
Yeah, I certainly can give you my perspective on those costs. With regard to the mechanics and the specifics, Mr. Reith would be better off. But I think the important thing to know about inline inspection cost and well logging is we have removed 100% of those costs as part of the stipulated adjustment, right? So there are no well logging and no inline inspection costs included in operating expenses in the forecasted test year.
So do those expenses generally fluctuate from year to year very much?
There is a possibility that they would fluctuate, but let me first clarify why we removed 100% of the cost. What we are seeking to do there is we are seeking to essentially treat those costs as capital cost. And so you have to remember, back in 2020, FERC issued an accounting order which the industry pushed for with regard to all the new costs that were coming about as a result of the mega rule. Mr. Reith can certainly talk a lot more about what that means and all the different features there, but there was an accounting order that came out from FERC that says for the initial inline inspection costs associated with that rule, utilities would be permitted to capitalize those costs. And so those costs would basically be set up and capitalized and then depreciated over a period of time. What we are asking to do, because these are on a cycle, I think it's like, I want to say it's a 7-year cycle, but Mr. Reith could certainly answer that better than I could and speak to it better than I could. But what we are really proposing is whatever cost we incur, we establish as a regulatory asset, and then we amortize that in the future over the life that's defined. Now, deferrals have gotten a lot of attention, and the one thing that I would want to say here is with regard to deferrals and what is the value for customers, right, with regard to the stipulation. First, it's a $31 million reduction in the revenue requirement, right? That's the amount of the deferrals that we have, deferral adjustments that are included. The other benefit that customers receive is that they pay no carrying cost on those deferrals until those costs are determined to be prudent and approved for base rate recovery in a subsequent proceeding, okay? And so the company is going to bear those carrying costs until they are approved in a base rate proceeding or in some other proceeding.
So the second inspection, according to that FERC order, second and subsequent, what did the FERC order advise as to the accounting for those?
It is only applicable for an initial inspection. So it's only applicable for the accounting rules would say it becomes O&M. Thus, that is why we need to make the request here and why we're requesting regulatory asset treatment and not capital treatment, right?
Okay. If the company was to defer the cost related to the well logging and inline inspection, what incentive would the company have to minimize the actual expenses at that point?
Yeah, as I mentioned just a few minutes ago, it really becomes the company is incentivized, right, it's not an open checkbook. First of all, these costs are going to be subject to the review of the commission. Mr. Conroy did a nice job of explaining that review process with regard to the vegetation management costs as well as the storm costs. But all of the items that are subject to deferral in this proceeding are going to be subject to a reporting requirement, right? So that we want to be as transparent as possible. And again, we are only seeking recovery of those costs which we deem are prudent and necessary. So that's the first point, right, is that there will be a review, and so that keeps us in check, and it makes sure that we have the right checks and balances. And then the other feature is, again, we are going to have to pay, the company is going to bear the cost, the carrying cost of those deferrals until they are subsequently approved by the commission and included in rates in the future.
Okay. I'm going to move on to, I think, the last, well, I'm going to move on to a totally different topic. According to your rebuttal testimony at page 7, I'll give you a minute if you'll let me know when you get there.
Okay.
So I think you say that while rate base and capitalization theoretically should be equal, it is rare that this happens. And those pages kind of discuss rate base valuation methodology versus capitalization, correct?
That's correct, sure.
Okay. And so I know that the company has asked for a certain valuation method. There's a valuation method set out in the stipulation. Prior to filing the application, did the company engage in an analysis into both methodologies, or did it just proceed with the one it used the last time?
Well, certainly, we're required to present both valuation methodologies. And we have clearly laid out in both direct testimony, Ms. Fackler, as well as my rebuttal testimony, why we believe capitalization is the superior methodology.
Okay, so I think that you go on, actually it's backwards in your rebuttal, but on page 2, to say that if rate base is adjusted appropriately, there's no material difference between rate base and capitalization. So I guess my question is, did the companies evaluate their application from the rate-based methodology and then the capitalization methodology and then pick the better one for the companies?
Well, first to answer the latter part, the company has used capitalization, right, consistently. We've used it for more than 40 years. Thus, it's a longstanding policy that's been valuation methodology that's been used by the company. I would note that the stipulation does include a section which has not been yet discussed with regards to one of the primary differences between capitalization and rate base, and that is the inclusion of regulatory assets and liabilities. So there is a provision, I would have to find the exact number in the stipulation, that talks about the companies, when they make their next filing, they will include regulatory assets and liabilities in rate base. And one of the reasons why that is in there is that today there is currently a mismatch in the company's filing. They're included in rate base today are the deferred tax assets and liabilities associated with the regulatory assets and liabilities. However, the regulatory assets and liabilities, the underlying assets and liabilities themselves, are not included in rate base. And that is one of the key primary differences between rate base and capitalization. And so once we decide to make that inclusion and get those aligned and remove that mismatch, then a more constructive debate probably can occur on the two different valuations. But they should be largely the same at that point in time.
So you mentioned policy in your response just a minute ago. Is the company's policy to choose capitalization at the methodology at this point?
It's the company's approach based on well-established history, if you will, we've used capitalization, again, as I mentioned, for more than 40 years in these rate case proceedings.
Okay. I'm gonna shift gears to the cost allocation manual. I believe you sponsored a lot of the responses related to the cost allocation manual and review of the allocated costs, but if you are not the right witness, will you just let me know? And
I will.
I'll ask whoever's appropriate. I think that according to information you provided, the cost allocation manual changed due to a merger between the parent company and another entity. Is that correct? Or was it just to merge the cost allocation manuals?
It was the result of the acquisition of Rhode Island Energy, right? And we took a look across all of the businesses and realized, right, as we started to centralize and have more shared service functions consolidated, we needed to update our cost allocation manual and have one consolidated manual across PPL.
So when the merger occurred, Louisville Gas and Electric and KU, your all's manual changed to reflect that acquisition? Or was it solely just to be unified across all PPL entities?
You're talking the 98 merger or what?
The Rhode Island, I'm sorry.
Right, there, we consolidated all the various cost allocation manuals to ensure that we had consistency. One manual for all PPL affiliates.
Okay. And then, can you talk a little bit about the categorical allocation ratios listed in the CAM? They're in Chapter 4.
I can try.
Okay. So, in Chapter 4, there appeared to be at least a couple new additions as far as the ratios go. And let me know when you're. It's in the cost allocation manual, which is exhibit application tab 51, or I think it was also provided again in exhibit 3 to his rebuttal.
I definitely know it's been provided, I'm just not sure where. Yeah, try here, Rick.
I think it was easier for me to find in tab 51, if that helps at all.
I would say you probably need to go to the filing requirements. Rick? Which that could have been Drew that sponsored it.
It's in Drew's.
All right, we got it.
Okay, sorry. Could you talk a little bit about, it appeared at least there were the addition of a rate base ratio and a plan assets ratio from the last cost allocation manual. And so obviously, I think we looked at like a 2011 version of your cost allocation manual. It may have been a little older than that. But can you talk a little bit about how the addition of these two new ratios affected LG&E and KU?
I don't know the specifics of that. We certainly can follow up with a post-hearing data request around how that may have impacted us.
Well, I don't know if you'll be able to help me out then much. My next question was, can you provide some examples, and we can ask it as a post-hearing data request, some examples of when those ratios might apply?
Yes. I'm not going to be able to answer that here.
Okay. And then, I don't know, this may have to be a post-hearing data request as well, but in chapter 3, there's a list of, well, there's a chart, and I'll give it a minute. It's,
In chapter 3, a chart in chapter 3?
basically, you provided the percentage of ratios for certain expenses in a different response, but in this chart, there's like, in certain categories of expenditures, there's 5 different ratios that might apply for some of them. Sometimes there's just 2 or 3.
Sure.
But it's unclear as to which ratio might be applied and how that would impact LG&E and KU as far as allocated cost goes. Can you explain how?
Yeah, I think there was a DR, it could have been asked by the commission staff with regard to why do we pick different methods? Like why, for example, are there 4 methods, for example, for one of these areas? And it really just depends on the nature of the service being provided. So, you know, one that's near and dear to my heart is obviously accounting, right? Accounting services. And you'll see there's a number of employees ratio, there's a number of operating segments ratio, there's a revenue ratio, there's a utility plant assets ratio. And so if you think a little bit about the makeup of the enterprise, there are a lot of these ratios really belong to a specific department. So for example, the utility plant assets ratio is likely our property accounting group. The revenue ratio, likely our revenue accounting team. The number of employees, that could be applicable across many different functions. The number of operating segments likely could be a financial reporting type feature there as well, with regard to folks that work on 10Qs or 10Ks and SEC reports that are based on really segments.
So, I guess that kind of leads me to the next part of my question, and I know Mr. Spinard asked a little bit about your titles and the structure, how you fit into the whole structure. I believe it was in your direct testimony that, and it may have been in response to a staff DR, the costs allocated for KU, for example, are reviewed by several departments, including PPL and LKS corporate accounting departments. Is there anyone with KU, we'll just say KU for now, specifically, that reviews any of the allocated costs, that doesn't have a shared title with a PPL company?
Typically, the accounting function is more of a service company function, and most of those employees, like I say, I think all the employees they're either employed by LK Services or PPL Services.
Okay. Let me double check. All right, I skipped over my note cards. I'm so sorry. There are 2 more that got passed to you. The question related to AFUDC also was passed to you, and it was has LG&E and KU studied whether to standardize using either AFUDC or CWIP to recover working capital? But not both.
To recover working capital. I'm not sure that I understand.
Well, I think right now you all book things, capital projects, 2 different ways, using AFUDC during construction or construction work in progress. Have you all studied using one method or the other method?
Well, we are using both methodologies today, right, with regard to setting rates in in Kentucky. We are utilizing AFUDC for only select and specific items. Obviously, those are typically the larger projects that typically require a CPCN. So we started using AFUDC for Kentucky retail purposes now, mind you, with AMI. So the AMI program started the use of AFUDC. Since then, we have expanded that to focus on not only the 2022 CPCN projects, we've also now expanded that to be the 2025 CPCN projects, with the exception of the SCR. So all the projects that are going to be included in the GCR are subject to AFUDC. Now that we are using that is for a specific purpose, and it makes sense with regard to those projects. Right? Those projects are typically major construction projects which have longer lead times and typically longer construction periods.
Well, that kind of leads into my follow-up then. What are the specific benefits to the company for choosing those particular projects and that type of accounting?
Well, I think benefits is a tricky word, right? It's a difference, is what I would say, between including CWIP and including AFUDC. And if you look at my rebuttal testimony, there's a lot of analysis around, a lot of history around which one's better and which is the preferred method and the like. And I would just say this, right? The company has recognized that both methodologies are appropriate, and the benefit of AFUDC is that it allows us to recover our financing cost as we are constructing these major assets.
Okay. And the last one, it is kind of gone from Conroy to Deascendis, and now I'm going to ask you a version of it, I guess. As to the 9.9 return for the rider mechanisms, explain whether you feel like this presents the riders present less risk for shareholders than recovery and base rates.
I think Mr. Deascendis did a nice job of explaining that he does not feel that to be the case, and certainly he would be more of the expert on this issue than me. But the way that I look at it, especially as it relates to the GCR, right? Absent the stay out provision, right, the company would have filed a rate case and would earn the authorized ROE, or the stipulated ROE, whatever that authorized ROE was. There would be no haircut. It would be the authorized stipulated ROE that was approved for base rates, if the company were to have filed a base rate case to recover those costs. I think that's extremely important to remember. The other thing that I would say, again, you have to think a lot about the two mechanisms working together. Right? We've clearly indicated that we think that we will under-earn the 9.9% during the stay-out period. But the GCR, being at the 9.9%, will serve to protect that. Granted, they are separate, but it will serve to protect the company's financial health. Right? And I think that's really important here, that I want to make really, I want to disclose, because Dylan mentioned that the company will have to acquire capital, right? And so to the extent that our earnings are below 9.4%, I think the sharing mechanism provides protection to our customers, because it provides and ensures that we continue to remain financially stable at a period of increasing capital, and that will again allow the companies to be able to attract low-cost capital, which will benefit customers over the life of those assets.
So I know we're going to ask for this in a post-hearing data request regarding actual return over the past year, but you mentioned that you think you will under-earn, which is why the mechanisms were proposed as part of the stipulation. Based on your last 18 months of actual return earned, do you believe that it will be consistently under-earned at a rate lower than 9.4?
It's difficult to predict, right? There are so many variables that are associated with our earnings. So as we sit here today, given the additional capital spend, we do anticipate that we will under-earn the 9.9% stipulated ROE. Now, to the extent that we earn below the 9.4, that is likely possible too. Because again, we are making significant capital investments in areas outside of the generation that's included in the GCR. So you've got the generation rider over here that's going to take care of the generation cost, and then the sharing mechanism, which is limited in duration. It's only 13 months. And it provides protection during that stay-out period, which is really valuable. And so the 50 basis point reduction, right, on the low end of the ROE band serves to benefit customers. Because again, had we not had the stay-out provision, we would have filed a rate case. And so in essence, when you look at the stipulated ROE, you can see that the impact of the ROE reduction in this case is approximately 84 million. Right, and so when you think about that, that's from 10.95 down to 9.9%, so 105 basis points. And so if you convert that 105 basis points into 50, right, you take the 84 divided by the 105, and then you multiply that times the 50, that's approximately 40 million. So for every 10 basis point reduction in the ROE, it's approximately $8 million. And so 8 million times 5 is 40 million. Customers are, in essence, during that stay-out period, are getting a discount if we earn below the 9.4% by $40 million. And that number will only increase as we spend more capital.
Thank you.
You're welcome.
Commissioner Wood.
I don't have any questions.
Do I have a couple? Good afternoon.
Good afternoon.
Were you involved in the stipulation discussions?
Yes.
If the projected cost savings or the efficiencies don't materialize, how does the stipulation allocate between the risk between the shareholders and ratepayers? And,
Are you
which
speaking to
risk,
the deferrals or?
risk categories?
Risk categories.
So IT cost, shared service costs. So if the efficiencies aren't met or the projected cost savings aren't there, what are the risks to the shareholders and what are the risks to the ratepayers?
In terms of the sharing mechanism?
Just in terms of protection from this not coming through.
Yeah, was certainly right. The sharing mechanism will be impacted
Okay?
by all features of the operating of the earnings, right? So it's to the extent that O&M savings don't materialize, right? That's additional costs, which could mean additional collections from customers. To the extent that to the extent that weather's favorable, that could serve to benefit customers. To the extent that O&M's lower, that could serve to benefit customers and lower any type of collection, and possibly even lead to a return.
Okay, and with respect to the affiliate costs and the shared billing from PPL, how does the stipulation address oversight of the affiliate billing and cost allocations?
I don't think it's specifically addressed in the stipulation.
Okay, so there's nothing in this stipulation that provides oversight between the cost allocations between PPL?
No, but again, I would say we will continue to do as we always have, right? We take our job very seriously, right? And we we are proud of the work that we do as a company. And we believe, every dollar we spend is subject to review by the Commission for Recovery. And so we believe that the company will continue to act as it always have on the best interest of its customers. What we think about when you think about the stipulation, I think it really strikes a really good balance, if you will, between ensuring customer protections, but also ensuring the company's financial health, and lastly, long-term reliability.
And I appreciate that, but there is no oversight in the stipulation that looks at cost allocation between the PPL companies. Is that correct?
Well, certainly, we review those costs that are charged.
I know you do, but
charged, yeah.
there's no oversight into that other than what you're saying.
I'm not sure I follow, right? I would argue that all the costs that are subject to this proceeding are subject to the oversight of this commission.
Okay, thank you. Sorry, what about cross-subsidization?
Yeah, so certainly when you look at the cost allocation manual, it really relies on the guidelines and principles from NARUC, right? And that really focuses on asymmetrical pricing. And so to try to explain that in simple terms is when non-regulated affiliates provide services to the regulated affiliate, right, they need to be at the lower of cost or market. When their regulated subsidiary provides services to a non-regulated affiliate, they are at the higher of cost or market. So that framework serves to be a protection for the utility and for its customers and its ratepayers.
Okay, thank you.
You're welcome.
You might not be the right person to ask this, but I meant to ask it earlier of one of the other witnesses. And so the Data Center Coalition filed a public comment in this hearing, or in this case, just earlier this week. Did you happen to see that?
I have not.
Okay. One of the things that it's a lengthy filing, but one of the things they wanted to do was clarify that they didn't think the company had necessarily worked with the Data Center Coalition on the parameters of their EHLF tariffs. Do you know who would be the best person to speak to that? Or is that you?
Well, certainly I've helped and been involved in the parameters around some of the data center tariff language as it relates to collateral. That's kind of my area's responsibility. Mr. Horner would be the better person around the overall provisions of the EHLF tariff.
Horner?
Yes.
Do this? Okay.
Mr. Bevington may also be a good person to ask on that as well.
Okay. Right, that's all the questions that I have. Redirect?
No redirect, Your Honor.
Right. Let's see, we're keeping Mr. Garrett, right? In addition to Mr. Conroy?
Yes, Your Honor.
All right, but, so, not excused, but excused from the stand.
Okay, thank you.
All right. You got time for another?
Yes, Your Honor, we call Mr. Lonnie Beller, his next witness.
Good afternoon, Mr. Beller.
Good afternoon.
Would you raise your right hand and be sworn? You swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. Tell us your full name and your business address.
My name is Lonnie E. Beller. My business address is 2701 East Point Parkway, Louisville, Kentucky, 40223.
Counsel?
Mr. Beller, could you please state your title of employment?
Yes, my title, I'm Executive Vice President of Engineering, Construction, and Generation for PPL Services.
Mr. Beller, did you cause to be filed direct testimony in this matter along with the application?
Yes,
And did you also sponsor a number of data requests that are of record in this proceeding?
yes, I did.
Do you have any corrections to your direct testimony or to any of the data responses that you provided in this case?
No, I do not.
Mr. Beller is available for questions, Your Honor.
Mr. Cook?
No questions.
Mr. Kurtz?
I do, Your Honor, thank you. Good afternoon, Mr. Beller.
Good afternoon.
Mill Creek 2, you're like the main guy for that?
Yes, sir.
Okay. Are you familiar with Supplemental Testimony Exhibit 5? It's been
Yes.
referred to? Okay, tell me if I'm looking at this correctly. Can you put that up on the screen, please? Or
Yeah, I have it.
Okay. Okay. This is the impact on consumers of the Mill Creek 2 stay open, correct?
Correct.
Okay. Let's look at 2028, the first year of the extension, because originally it was going to retire in 27, but now it's going to stay open through 28, 29, 30, possibly longer.
Correct.
Okay. So $8.5 million total system revenue requirement to keep the 300 megawatt Mill Creek Unit 2 open?
Correct. Scroll down, Rick.
Okay.
That's the total cost, right? And then you have Group 1 and Group 2 allocations in the schedule, correct?
Right, and you can see the 8.5 million is total system revenue requirement.
Correct.
Okay. And then there will also be $3 million of fuel savings estimated.
Correct.
So that would knock it down to 5.5 million.
Net customer impact, correct.
The estimated residential impact on line 20 in 2028 is 74 cents a month.
Yes.
Okay, and if we knock out a third because of the fuel savings, it would be about, 50 cents a month.
That's fair, correct.
Okay. So the 300 megawatt Mill Creek Unit 2 at a cost of about 50 cents a month in 2028 to the average residential customer. What's the typical capacity factor on Mill Creek Unit 2?
It can vary depending on maintenance schedules for other units, but I would say as a general rule, above 65%.
Okay, I did 60%, I won't do the math again, but I get 1.57 million megawatt hours a year.
Sounds reasonable.
And LG&E's total retail sales are about 20 million megawatt hours a year.
Total would be closer to 30, but.
Oh, that's actually KU and LG&E.
Correct.
So
Both
LG&E.
KU and LG&E would be closer to 30, yes.
But LG&E is more like 11, 12.
Subject to check. I think about the companies together, not separate.
So one.
Your Honor, I'm sorry, I need to object here. This is, again, I mean, I realize that the MC2 is new to this docket, but they were a signatory to this mechanism in the last case. This is just friendly cross, designed to bolster the case of the company on something that KIUC has already come out directly in support of.
I believe I've already ruled that it's still cross, and that this is something that was not part of the stipulation.
Correct, this is new.
Yeah,
Okay, so 1.5 million megawatt hours out of Mill Creek Unit 2 is about 15% of LG&E's total retail sales, in that ballpark.
Correct, based on the 11 gigawatts, yes.
So that's a lot of energy out of this unit for 50 cents a month.
As we've had a lot of discussions in the CPCN case, and the commission recognized in their order, there is value to the continued operation of Mill Creek 2.
And this cost of about 50 cents a month does not include any additional profits from off-system sales made by Mill Creek Unit 2?
That was not part of the calculation provided on Friday, no.
How are the companies doing on off-system sales?
This year, we've had favorable conditions, favorable market prices, and have done well, and as I think is generally known, about 75% of that goes back to customers.
So you sell into the high-priced PJM market, for example?
We sell into all markets, but PJM is a common market in which we sell into.
So that's a good market to be long, and
definitely.
You follow industry trends with respect to coal plant life extensions?
Yes, I read industry trade publications and generally aware of what's going on in the industry.
Are you aware that Southern Company has recently announced the life extension of 8,200 megawatts of coal units in Mississippi and Georgia?
Yes, I read that.
Are you aware that Dominion is extending the life of one of its coal units in South Carolina?
Yes, I recall reading that.
Okay, what about Duke, North Carolina, extending the life of its coal units?
Yes, it's a fairly common trend in the industry today to extend lives of existing assets given the load growth that we're seeing, whether you're in an RTO or out of an RTO.
What are the other factors, in your opinion, leading to this nationwide trend of extending the life of coal units?
Well, we've had many discussions in a prior CPCN about the pending EPA rules directed at greenhouse gases, and those rules in proposed form would have been very onerous to comply with, would have resulted in retirements of fossil assets. Those rules now are not pending, and so I do believe that, coupled with load growth that we've seen in the industry that we've talked about quite a bit in this room in the past, have led companies to hold on to capacity where possible, where feasible, to be able to meet load and comply with environmental regulations.
Will keeping the 300 megawatt Mill Creek Unit 2 open past 2027 aid in economic development?
Yes, as part of the CPCN proceeding, the stipulation and the approval of the commission, the companies withdrew their request for 400 megawatts of batteries for a variety of reasons. Having the 300 megawatts of Mill Creek 2 will fill that gap and aid in economic development that wouldn't otherwise be available to the companies if we were not to extend the operation of the unit past 2027.
Last couple questions. Do you know how much Mill Creek Unit 2 coal comes from Kentucky?
We buy coal from barge and from rail, and a majority of that coal comes from Kentucky. All of the rail coal comes from Kentucky. I know that off the top of my head, but a majority of the coal does come from Kentucky.
How many tons a year does Mill Creek 2 typically burn?
I would have to check that, but I would suggest over 1 million tons a year, but we can provide that as post-hearing data request.
Okay. Thank you, Mr. Beller. No more questions, Your Honor.
Sierra Club.
Thank you, Your Honor. Good afternoon, Mr. Beller. I'm Nathaniel Schoaf on behalf of Sierra Club.
Yes, good afternoon.
It's nice to see you.
Nice to see you.
I have a couple of questions for you. These relate to Mill Creek 2 and to the cost recovery mechanism that was first introduced in this case as part of the Halloween testimony of Exhibit 5, the bill impact analysis. Okay, let's start with the basics. What do stay open costs entail for a unit like Mill Creek 2?
Okay, maybe I could start, since I've heard a lot of testimony, in talking about what stay out means to us as a company and the way we apply it to Mill Creek 2.
So, sorry to interrupt you. I misspoke. I said stay out. I meant the stay open cost.
Oh, okay, I've heard stay open. I didn't hear stay out.
You were heading in the right direction.
Yeah, I was in the right direction, okay. All right, so let me start with that, and then I'll address your question. The way we think about stay open costs is we were managing Mill Creek 2 to shut down in June of 27. So the decisions we've been making for quite a while have been around that shutdown date. When we do inspections, when we find problems with the unit, that all informs what we do. If, for example, if we see a piece of equipment that we would normally replace if we were going to operate the unit in perpetuity, but we think it might last until the June 27, we wouldn't make that investment. Maybe we make a repair, patch, if you will, so that we're not spending any funds that don't provide value or reliability of that unit. And so we've been doing that. Now, since about July of this year, we've reversed that philosophy, extended that to mid-2027 in-service date. So all of our decisions that we make are directed at that, if you will, soft landing. And the premise of all of our decisions is the unit has to be safe, number one. If you've ever been to a coal plant, there are a lot of things in the plant that are moving. There's high temperatures, and we need to make sure all of that is controlled in a safe way. So that's number one. And then we want the unit to be reasonably reliable up until the day we turn it off. We're not looking for gold-class reliability the last 6 months we operate the unit, but we are depending on it to serve load and to provide value. So we make our decisions with all that in mind. So with the questions you asked, that's how we think about stay open costs. And I'll stop there and then let you proceed.
Thank you, Mr. Beller. With those, some of those costs, those include maintenance on an outage that occurred this fall?
Correct. For example, in October, we just finished an outage. As mentioned, the unit came back on over the weekend, and we replaced what we call the bag houses. It's part of the back end particulate control, and we replaced the bag houses, and that project was rethought based on the need to operate that unit for now another 4+ years versus it being operated in 2000 or shut down in June of 2027.
And the decisions that you're making now, are they to keep the plant open until 2031 and Mill Creek 6 comes online, or indefinitely beyond that date?
Now we're looking for that. We're making decisions based on what I'll term a soft landing in June of 2031, not operate the unit indefinitely.
Okay, thank you. Let's go back to the costs that are entailed in these stay open costs. Would it include putting an SCR on that facility?
No. We don't see a requirement to do that, environmental requirement. If that came along, obviously we would have to adjust our thinking. As a general rule, that level of expenditure would not be cost justified just to extend the life of a unit, 4 years extension or operate it for 5 years. So we wouldn't contemplate an SCR as part of the cost to create that soft landing for 2031.
How about costs associated with obtaining new air permits for Mill Creek 2?
I do not believe we need to obtain any new permits. If there are any permit modifications that need to be made along the way, of course we would do those.
To date, have any of the stay open costs included costs associated with obtaining new air permits or permit modifications for Mill Creek 2?
I can provide that as a post-hearing data response. I'm not aware of that, but there could be some minor permit modification that wouldn't come across my desk that's been made, and we can definitely provide that as a post-hearing data response.
We'd be happy to submit that.
Yeah.
All right, next question. What is the total amount of stay open cost the company has incurred to date?
So, and this will come back to explaining the mechanism a little more fully, if you bear with me. So the company's proposed in the original CPCN, a Mill Creek 2, in the previous CPCN, a Mill Creek 2 mechanism to recover cost of continuing to operate the unit. And on the O&M side, in that mechanism, we had defined those costs as costs above those being recovered in base rates. Mr. Garrett testified to that through some questioning. We have repeated that definition in the filing that was made on Friday with respect to the Mill Creek 2 mechanism. So I explain that because that's the context in which we produce the numbers that are on the exhibits that were provided on Friday also. This is with respect to O&M. So as you work through that schedule, what you're seeing is O&M that we are spending that's above, or we project to spend, that's above what's in base rates. And we would identify those as stay open costs, as opposed, and I know this is part of your question, on the O&M basis of trying to identify every work order, if you will, or every action that an employee takes at the plant and deciding whether that's stay open or not. That's a reasonable mechanism in the sense that it ensures that we only recover O&M costs we incur, and we credit back anything that's being recovered in base rates. And that's why when Mr. Garrett testified, there were some negative numbers in certain months because of the way that calculation will work out against our projected spend.
Is that it?
For capital, it is a different story. If you look at our capital that we included in the 2026 test year, I think it's under 300,000. So in the mechanism recovery, we would propose all capital expenditures, given that we were planning to shut the unit down in 27, they would be de minimis, but all capital expenditures now, which would be much greater than they would have been otherwise, should be recovered through the mechanism.
Okay, I think I heard you reference 300,000 capital expenditures in 2026. Here's my question. I don't need you to turn to that number. What's the total amount of stay open costs that have been incurred to date, which would be just July of 2025 when you started incurring those costs through today?
So that would be reflected, consistent with Mr. Garrett's testimony in the schedules that we've provided. The caveat, and Mr. Garrett pointed this out, is that October in that schedule is unlikely to be actual costs because we wouldn't have closed the books in time to include it in this schedule. But as a post-hearing data response, we can parse out what has been provided as to what's actual, which is the very specific point of your question, and what is projected.
Got it. So there's no way for us to look at that, what's been provided so far, that information, and determine on our own what's projected and what's actual? That has to be addressed in a post-hearing request.
Correct. The July, August, and September numbers are known as actuals, and I would presume they're reflected in here. My question would be relating to October and forward. I wouldn't suggest that those are actuals at this point in time.
Okay. I want to ask you a question about the testimony that was filed. I know it's not your testimony, but when I asked your colleagues, both of them deferred to you. They indicated that there were reasonable assumptions and modeling that went into this bill analysis that's on this Exhibit 5 that I believe you're looking at now. My question to you is, what are those assumptions that went into making Exhibit 5?
Oh, sure. So if you look at projections, and that's why I went through the explanation of how we're managing the unit. And so let's break it up between O&M and capital. O&M, we have a revised budget until 2030 reflected here for the plant. And the assumptions made there are that budget against costs that we presume will be allowed to be recovered via this rate case, and netting of those, and that's what you see for the O&M. So that's how we got to the O&M, a bottoms-up plan by the station as to what work needs to be done that will be charged to O&M. Likewise, in capital, we have that same budget lined out. At a certain level, they are detailed work plans that we believe will be required in the outages that we have and in order to keep the unit operating through 2031. And all those business plans are the foundation of the numbers you see in the schedules.
Thank you. Your colleagues wrote in their testimony that these numbers are illustrative and not predictive of final outcomes. My question to you is, should customers expect that those numbers change by 30%, 50%, an order of magnitude, something else?
Sure, fair question. So, as I just explained, we built those up on what we know about the condition of the unit. Again, we just had an outage, so we know even more about that through the inspections we performed there. And so those numbers would only change if conditions arise that are inconsistent with what we have in our budget and our planning. So I wouldn't want to give a percentage. They could go up or they could go down. And again, the reason I went through that description, we will always assess those expenditures as to are they absolutely necessary to continue to operate the unit through 2031. And if they're not, we obviously wouldn't expend them or look for a lower cost alternative.
Okay. With regard to this decision point the company has to make with regard to keep Mill Creek 2 open past 2027, has that decision already been made?
So there's two pieces to that. There's the operational piece, and the operational piece, that is exactly what we're planning to do, is continue to operate that unit. The commission has pointed out in their order that there is a risk related to our authority under Senate Bill 4 to retire that unit. The companies haven't formulated their strategy around that risk and how we plan to mitigate that. But those are two separate things in my mind. But operationally today, and when we had the unit in outage, we were thinking toward a 2031 retirement date, not a 2027 retirement date.
Thank you. My next question is, has your company notified its customers that it intends to keep this coal plant open beyond 2027?
So we obviously communicate with our customers in many ways. I would say on this particular issue, it would be via press releases that we've issued, both in the CPCN that would have highlighted that as an outcome of the settlement agreement. That press release would have been issued contemporary with that that settlement agreement being filed with the commission. In the order of the case, we would have talked about that in a press release. And then if the mechanism is approved by the commission, we have on our website understanding your bill type information, so customers would be able to see from that what the Mill Creek 2 adjustment mechanism was and what it's about.
Let me just make sure I have the timeline right. When was the decision made to keep Mill Creek open beyond 2027?
So we did a couple of analyses that were submitted in the CPCN case. I believe one either May, June, or June, July time period. And then we went into settlement discussions. Lots of things were going on at that time. If you recall, there were tariff uncertainties, there were uncertainties about tax credits. And so that issue was on the table. And then, of course, once we agreed to the stipulation in the CPCM, in my mind, that's when the company made the decision we were going to pursue that option to continue to operate Mill Creek 2.
Okay, and that stipulation, the CPCN docket, was July of 2025?
Correct.
Did the company tell its customers in any of the public meetings for this docket that it intended to keep the coal plant open beyond 2027?
Not in this docket. The companies had the expectation that the CPCN proceeding would result in approval, if you will, to continue to operate Mill Creek 2, which it did. The mechanism, of course, was not part of that. So we didn't, up until a week ago today, feel it necessary to have conversations related to Mill Creek 2 continued operation in this proceeding.
So the answer is your customers don't know? Unless they're tracking these Public Service Commission dockets and reading commission orders, they don't know that you intend to keep Mill Creek 2 open past 2027.
Press releases we issue, correct, we did not send any public notice to every customer on that topic, no.
Okay. If the cost recovery mechanism here is approved, I have never been through this process before. If it's approved, and start having these monthly filings with 10 days to review by staff, I think that's the way this cost recovery mechanism would work. Is that?
Mr. Conroy explained that process, and I'm familiar that it would be similar to what's in the ECR, that they would be submitted, customer bills would change, but there would be a subsequent review process to evaluate prudency of those expenditures.
Do customers get notice of that process, and is there a way for them to engage in that prudency determination that's made by the commission?
obviously, customers can and do on a regular basis call our call centers and ask questions about their billing components, so they would have that opportunity to participate. They do file complaints with the commission and other bodies related to our billing, so they would have opportunities to seek appropriate to file complaints and do what they do as it exists today.
Okay, but under the, I appreciate they have an opportunity to file complaints with the state. My question is, under the mechanism that your companies put forward on Friday and that you're testifying to today, do customers get notice of that process, and is there a available avenue for them to participate in that process?
Other than what I described, I'm not aware of there being a way for them to participate in the mechanism.
Okay, but what you described is a process by which they could file a complaint with the commission or call up some of your staff and complain about their bill or ask questions about the bill. That's different than having a process in this cost recovery mechanism process.
Yes, it's different than the participating in the monthly filings, correct?
Okay. Mr. Beller, I appreciate your time. I don't have any other questions for you today. Thank you.
Okay. KYSEIA.
Yes, Your Honor, we have some questions. Good afternoon.
Good afternoon.
I'm going to ask you some questions, and a lot of my questions are going to just get your general understanding. If I want to know about a particular unit or a particular project, I'll tell you, okay?
Okay.
All right. So, Vice President, Engineering, Construction, and Generation, is that correct?
Correct.
And on page 1 of your testimony, line 18, your career with the companies dates back to 1987, is that correct?
Yes.
And you were an electrical engineer with KU's Generation System Planning Group.
That's where I started, yes, sir.
Okay. And you've had different roles within the company and then later the companies, and now PPL. And one of the roles that you had on page 2 is Vice President, State Regulation and Rates from 2013 to early 2017. Is that correct?
Correct.
So, without being granular, you do you understand the basic nature of tariffs and the basic nature of rate cases and revenue requirements and that facet of how the companies fund their operations?
Yes.
Okay, thank you. So, with regard to a question that you were asked previously in the cross-examination, do you remember a question being asked concerning capacity factor for Mill Creek 2?
Yes.
Okay, and I'm sorry if it's unfair. I just want to know if you I don't want you to remember the question, but capacity factor is something you discussed previously today. Is that correct?
Correct.
Okay, and in terms of capacity factor, is the capacity factor in a very general discussion, is capacity factor the portion of the maximum potential energy output over some period of time that the generating unit produces? Is it the portion of what the unit's capable of doing?
Correct. If the unit ran at full load all year, that would be 100% capacity factor. So the capacity factor is a ratio, yes.
Okay, all right. And just ballpark numbers with regard to Mill Creek 2, the capacity factor is in the range of about 60%?
Yes, and subject to check, but that's a reasonable range, yes.
Certainly, thank you. So, with regard to at one stage, did the companies obtain an order of this commission that, and I'm not talking about your strategy about whether or not you're going to use it or any legal understandings or anything like that. This is a very general question. did the companies obtain from this commission an order that would allow the companies or authorize the companies to retire Mill Creek 2?
Your Honor, I do object to that question. It is a question asking for Mr. Beller's legal interpretation of the commission's order. The commission's order had a lot of discussion about Mill Creek 2, retirement dates, and advisory opinions, and Mill Creek 2 mechanism, and all of that. It's a complicated order, as the commission is well aware. If Mr. Beller feels like he can answer it, that's fine, but I know Mr. Spinard caveated his question that he's not seeking a legal opinion. It's hard for me to think how the answer to that question is anything but a legal opinion, because it is the interpretation of a commission order. Having said that, if Mr. Beller can answer it, that's fine.
If he knows. Were you finished answering?
So, in listening to your question, I would have one clarification. Are you talking about the order we received a week ago, or the order we received in the prior CPCN that allowed us to retire the unit in 2027?
The prior, yes.
Yes. So when we had the lengthy discussion in, I don't remember the case number, but and the first application of Senate Bill 4, yes, I do recall receiving an order that authorized us to be able to retire Mill Creek 1 and 2, actually. Mill Creek 1 at the end of 24, Mill Creek 2 in 2027. Or, in effect, that retirement date was actually tied to the in-service date of Mill Creek 5.
Okay, thank you. So there's been a lot of discussion today, and there's a lot of evidence in the record, and we have this whole discussion about stay open. My question is very general and very plain speaking. At this stage, why do the companies believe that there's a need to consider the continued operation of Mill Creek number 2?
Well, I think all that was laid out in the CPCN that we received in order again in a week ago. And so all that's contained into that record is the reasons that we believe today that we should continue to operate that unit. There were a lot of evidence, as you know. The companies withdrew their request to construct batteries at our Cane Run station as part of that exchange and the stipulation. So we can go through all that, but I would just point back to the record in that case.
Your general answer on that is perfect. Thank you. And I want perhaps another general answer. And if you ever want to elaborate, that's fine. But I'm seeking very general answers. Is it fair to state that the companies believe that they need Mill Creek number 2's generation?
Need, and we believe it will benefit our customers too. And that's recognized in the Commission's order of a week ago.
Okay, thank you. And you are actually a PPL service company employee, is that correct?
Correct.
Okay. In terms of the testimony that you filed on May 30th, 2025, and this is page 5, the first line, is a statement, generation output is jointly dispatched between KU and LG&E to achieve operational efficiencies. Do you remember that?
Yes.
Okay. Are there any assets held by KU or, well, let me take a step back to get the foundation. Are some of the assets owned uniquely by either KU or LG&E?
Yes, there are units that are 100% owned by KU and 100% and units 100% owned by LG&E, and there are units that are jointly owned in various percentages between the two companies. And that has to do with The rate making, of course, as I stated, and you set the premise for, we dispatch those units to meet load, irrespective of their ownership percentages.
Okay, so there's no unit that is uniquely serving, in terms of the dispatch, there's no unit that uniquely serves KU or uniquely serves LG&E.
There is a process within the fuel adjustment calls where generation is, for cost recovery purposes, assigned to the relative loads, but in general, the units are dispatched to meet the load. That is a post process. It doesn't affect how those units are operated.
Okay, so it doesn't affect how the electrons flow?
Correct.
Okay.
Nor how we choose which unit to operate. It's a process that occurs after the operation of the units.
Okay. And on that same page, page 5, line 5, dispatch of generation, whether from the company's own generating plant or from purchased power, is determined by the lowest variable operating cost regardless of ownership. And I think that's what you were describing just a minute ago, is that correct? Okay. So, in terms of the company's own generating plant, those are things that are in the rate base, is that correct?
Correct.
Okay. And so when the company adds generating plant into its rate base, these are very general terms. If you want to elaborate, you can. But when the company adds into the rate base, they're going to have capital costs associated with the construction, and then there's a carrying cost associated with supporting the construction. Is that correct?
Correct, yes.
Okay. All right.
We have to come up with cash to pay the bills, yes.
Okay. And then there's depreciation over the life of that plant associated with that asset that's in the rate base. Is that correct?
Correct.
So, and in terms of cost, you have some costs that are fixed cost, and then some costs that are variable costs. Is that correct?
Correct.
And so those, go ahead. I'm sorry, I may have interrupted you.
No.
Okay. So when you put those capital costs in the rate base, although they're depreciated over time, they have a characteristic of being a fixed cost. It doesn't matter whether or not the unit's running, that fixed cost is there, and the recovery of that cost is not by reference to how the capacity factor.
Correct. I mean, there's a general standard that an asset included in rate base should be used and useful for the companies, regardless of what the asset is, but it doesn't matter whether the unit runs, in our example, 50 or 60% capacity factor, if that's what you're getting at.
Perfect answer. But with regard to total cost, when the unit is running, for example, for some of your units, the fossil units, when the unit's running, there will be fuel costs associated with that unit, correct?
Correct.
Okay. And then I think perhaps you've mentioned that when some of the units are running, there are also maintenance costs that are related to the fact that the unit's running.
They can be directly tied to that. There are consumables in the case of a coal unit to operate the pollution control equipment and costs of that nature.
Okay. And when you were testifying earlier, and this is your testimony, and if I misstate it, you're going to correct me, of course. When you were testifying earlier, is that there was a stage with regard to Mill Creek 2 where when you were looking at the utilization of that unit and you were looking at maintenance and keeping it running, there were some things that at one stage you were saying, we're just going to keep it running, but then there was a change that said we need to rethink maintenance associated with Mill Creek 2. Is that a fair characterization?
Yes, both in a real-time and a planning basis. I would only add to your statement how we operate the unit, how we maintain it real-time, and also how we plan to operate it in the nearer term.
Okay, thank you. With regard to the company's generation, we talked about the fact that you have your own generation plants that are in your rate, in somebody's rate base, is that correct?
Correct.
You have control.
LG&E or KU, correct, and we have control of them, yes.
And I'm not going to ask you to go through every single one. I'm just going to, very broad characterization. You have some coal plants, correct?
Correct,
And you have some gas plants?
correct.
Correct. And if you were at KU, you have a hydro facility that the impoundment of Lake Harrington, that Dick's Dam, that's a hydro facility, is that correct?
Yes,
Okay, and one of the characteristics of Dick's Dam is that when it is operating and generating electricity, is there a fuel cost associated with it?
no,
Okay, and once upon a time, did KU own a second hydro facility, which was much smaller, on the Kentucky River around Lock 6?
Block 7, but yes.
Lock 7, thank you. And with regard to the prior KU facility on Lock 7, what happened to it? Did KU divest itself of that? Does that continue to be in KU's plant, or
No,
is that?
No, it does not.
Okay, and what happened to it?
I would have to go back in my memory bank, but we transferred that asset away based on what we saw as future cost obligations that we didn't think were prudent for the company to incur, is my recollection of the situation with Lock 7.
Thank you, that's perfect. So with regard to generation, is the characterization of the company-owned generation assets that that the companies have a broad spectrum of generation assets? And if I may, for the foundation, you've said you have coal plants, correct?
Correct.
Gas plants, correct?
Correct.
You have hydro facilities on the Ohio and also in the Kentucky River Basin.
Correct.
Do you have solar facilities?
We have 2 solar facilities. They're much smaller than the ones we're constructing now, but we do have 2 solar facilities.
Do you have a wind facility?
As a research project, we do have a very small wind facility, but it's a research project, but obviously it generates electricity.
Okay. Do you have, at some stage, did you receive approval in the certificate proceeding for a battery energy storage system?
Yes, and we're in the course of, building that as we speak.
Okay. And even before you received that certificate, was there a battery energy storage system in one or both of the company's portfolio of assets?
Yeah, again, similar to the wind turbine, as what I would call more of a research project, we have a 1 megawatt, 2 megawatt hour battery. It's been at Brown Station for quite some time.
Okay, thank you. To your knowledge, is the company currently, do either of the companies have an economic development tariff rider? If you know.
Obviously, it'd be in the record, but we have a tariff that allows for a declining discount for new customers that meet the criteria specified in the tariff. I'm sure I knew at one time, but I wouldn't be able to quote that criteria, but that's the only tariff I'm aware of that's focused on economic development.
Okay, that may actually be a better question for another witness, and I may ask another witness. It's very granular, and I apologize. I don't mean to put you on the spot.
Yeah, Mr. Bevington, obviously is head of our economic development and would be very familiar with the aspects of the tariff.
Okay. And this is if you know, and otherwise I'll defer to at least Mr. Bevington, if you know, what is your understanding? Because you were at some stage in the rates function. What is your understanding about when that economic development tariff rider can be used? Specifically, what we're getting to is that do the companies have to have excess capacity in order to utilize that rider, if you know?
My recollection is that is the case, but I would refer to Mr. Bevington to talk about the current application of the rider.
Fantastic. We'll ask Mr. Bevington those questions. Thank you. I asked a question of a prior witness about the PPL acquisition, and again, with the running start, I don't think I could pronounce the one word, but Rhode Island Energy is how I refer to it. You mentioned that in your testimony?
Correct.
Okay, and again, this is your testimony. Line 23, page 2, the consummation of this transaction created additional scale and scope to PPL's operations. Do you remember saying that?
Yes.
Okay. And in very general terms, what do you mean by that? Just tell me very general terms. If it's created something, help me understand what it's created.
Sure. So if you step back, PPL is a corporation, owned LKE, the Kentucky Utilities, and our service in Virginia, and owned a regulated electric utility in Pennsylvania, and a large distribution operator in the UK. And so when the companies disposed and sold the large distribution operator in the UK and bought Rhode Island Energy, that created more scope to the presence of PPL in the United States and created 3 operating companies, all generally of the same type, operating different assets under different regulatory constructs. But that created a more focused company on U.S. operations solely.
With regard to the PPL family, is it fair characterization that you all, that part of that notion of scale, you all get to learn from one another?
Correct. And part of the consolidation of groups, actually the group that I'm in charge of, I'm responsible for engineering and construction in Kentucky, Pennsylvania, and also Rhode Island.
Okay.
So we are able to share ideas, concepts, best practices across what we call the 3 operating companies.
Okay, thank you. With regard to your testimony on page 5, there's also this, we talked about this a little bit earlier, dispatch of generation, and its own generating plant or from purchase power. So is it in very general terms, when we talk about purchase power, are we talking about PPAs?
It could be a PPA, or it could be just an hourly or daily purchase of energy that's more economic than it would be to produce from our own units.
Okay. And I don't understand the terminology, and this is why it's important, is that when you talk about, is that just akin to a spot purchase?
Correct.
Okay, so, all right. I only have maybe just one question about this, hopefully. It is about OVEC. You're familiar with OVEC?
Yes.
Okay. How do the companies characterize purchases of energy from OVEC? Do they characterize these as part of their own generation plant, or do they characterize these as purchase power?
It would be characterized as purchase power in a more general sense, not our own generation, correct?
Okay, thank you. And hopefully that's the only question I'm going to ask you about OVEC. Okay. Page 10 of your testimony that was filed on May 30th. There's a discussion about CTs, and that's combustion turbines, is that correct?
Yes,
Okay. And your testimony on line 1, RCTs are also performing reliably. Because, and it continues, because combustion turbines are typically deployed as peaking or on-demand units, the startup consistency of these units is critical. Do you recall that testimony?
yes,
So when they're described as a, CT is described as a peaking unit, is it fair to say that you don't expect to use that unit all of the time?
yes, correct.
Okay. All right. But if those units are in rate base, you will still have the capital cost, and there will be a recovery that has to be supported regardless of whether or not you're using that unit all the time. Is that correct?
Correct.
Okay. Thank you. I think that's it. We're going to ask Mr. Bevington some of the other questions, but Mr. Beller's been a good witness, and I appreciate all his answers. Thank you.
Okay, so we'll move to the joint interveners, and I'll say that we'll look for a stopping point at 5.
Great.
Well, I just assumed you had questions.
I do,
Safe to say.
but I will try to be done by 5.
Sure. Want us to go off the record, Candace? Okay, let's take 5.
That stretch sounds like. Yeah.
for the day and let joint interveners start with their questioning fresh in the morning.
Got it.
Your Honor, I have one housekeeping, just a
Absolutely.
question. We're still not through 5 witnesses, right? So, I didn't know if the commission would be interested in the companies, at least talking to all of the interveners to see if of the remaining company witnesses, there are any, that people don't have any questions for
Right,
at all.
great idea.
And that way we would at least know
Yep.
what the burden is for the next 2 days in terms of how many witnesses, so we can schedule accordingly.
Yep.
If you want us to try to find that
Yes,
out, we'd be happy to. Obviously, if staff has questions or if the commissioners have questions, then, that will all come at a later time. But I thought it might make sense to at least explore that.
Yep, parties talk tonight, let us know in the morning, and I'll ask staff to let us know in the morning as well, if there's any questions, any witnesses that. Yeah, Mr. Cook.
Chair, Mr. Collin needs to get done by Thursday.
Okay.
So-
Anybody have objection to making sure Mr. Cullen gets in on Thursday?
No objection.
No, Your Honor. I think our witnesses are planning to travel on Friday as well, but we can make them available virtually if for some reason they're not available on Thursday. But we can maybe address that as we approach the end of the week.
Let's have this conversation.
Yeah.
Right now, because there may not be cross for your witnesses.
Yep,
Yeah.
let's go off.
I'm
the
fine
record
on
then,
doing that
and,
now off the record, yeah.
I'll see everyone back in the morning.
Thank you, Your Honor.
Thanks.